Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, Amen, Namaste.
Oath or affirmation. Announcements by the Speaker.
Honourable members, I have received communication from Mr. David Lee, MP, member for Point Apare, Dr. Rudal Munilal, MP, member for Oropouche East, and Mr. Dinesh Rambali, MP, member for Chaguanas West, who have requested leave of absence from today's sitting. The leave which the members seek is granted. Honourable members, as you are all aware of the assassination of the President of Haiti, President Moïse, earlier this week, and therefore I would ask and invite us all to stand and observe a moment's silence. May his soul rest in peace. Amen. Thank you. And before we proceed any further, I'd ask all members to kindly put their devices on silent. Thank you.
Bills brought from the Senate. The Quarantine Amendment Bill 2021 in the name of the Attorney General.
Attorney General.
Madam Speaker, in accordance with Standing Order 64.1b, I beg to move that the next stage of the Quarantine Amendment Bill 2021 be taken later in the proceedings.
Honourable members, the question is that the next stage of the Quarantine Amendment Bill 2021 be taken later in the proceedings. All in favour say aye. Aye. Any against? The ayes have it.
Papers.
Deputy Speaker.
Thank you, Madam Speaker. Madam Speaker, I have the honour to lay the following paper. 1. The notification of Her Excellency, the President, in respect of the nomination of Dr. Susan Craig James for appointment as a member of the Police Service Commission. Thank you, Madam Speaker.
The Minister of Finance.
Thank you, Madam Speaker. I have the honor to lay the report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Office of Procurement Regulations for the year ended September 30th, 2020. I beg to move that this paper be referred to the Public Accounts Committee.
Honourable members, the question is that paper 2 be referred to the Public Accounts Committee. All in favour say aye. Any against? The ayes have it.
Reports from committees.
Member for Miaro.
Thank you very much, Madam Speaker. Madam Speaker, I have the honor to present the following reports. The first report of the Public Accounts Enterprise Committee on the examination of the audited financial statements of the Urban Development Corporation of Trinidad and Tobago Limited for the financial year 2014 and 2015, first session 2020-2021, 12th Parliament. The second report of the Public Accounts Enterprise Committee on the examination of the audited financial statements of the Vehicle Management Corporation of Trinidad and Tobago Limited for the financial years 2013 and 2014, first session 2020-2021, 12th Parliament. The third report of the Public Accounts Enterprise Committee on the examination of the audited financial statements of the National Gas Company of Trinidad and Tobago Limited for the years 2016 to 2018, first session 2020-2021, 12th Parliament. The follow-up report for the Public Accounts Enterprise Committee on the examination of the 24th report, 5th session 2019-2020, 11th Parliament, on the audited financial statements of the Export-Import Bank of Trinidad and Tobago for the years 2012 to 2017. The fourth report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the National Information and Communications Technology Company Limited, IGOV-TT, for the financial years 2015 to 2019, first session 2020-2021, 12th Parliament. Thank you.
The member for St. Joseph.
Thank you very much, Madam Speaker. Madam Speaker, I have the honor to present the following report. The first report of the Joint Select Committee on Foreign Affairs on an examination of the foreign policy of Trinidad and Tobago, first session 2020-2021, 12th Parliament. Many thanks.
The member for La Hoqueta, Talparo.
Madam Speaker, I have the honor to present the following reports. The first report of the Joint Select Committee on State Enterprises on an inquiry to understand the impact of COVID-19 pandemic on the operations of National Schools Dietary Services Limited, NSDSL, and the measures implemented to ensure the delivery of meals in the context of the COVID-19 safety requirements, first session 2020-2021, 12th Parliament. The second report of the Joint Select Committee on State Enterprises on an inquiry into the operations of the National Infrastructure Development Company Limited, NIDCO, including its compulsory land acquisition in relation to major projects, first session 2020-2021, 12th Parliament.
Prime Minister's questions.
Member for Chaguanas East.
Thank you, Madam Speaker. Madam Speaker, could the Prime Minister advise the House of the present status of salary relief and income support grants since the initiation of the lockdown of May 2021 to present?
Prime Minister.
Thank you very much, Madam Speaker. Madam Speaker, since this situation has developed and arrangements have been made, the Ministry of Social Development and Family Services, along with the Ministry of Finance, have made a lot of provisions and have put out invitations to qualified persons to indicate their circumstance and to establish their qualification for receiving these grants, and that matter has gone on full speed ahead. and the Ministry of Finance has indicated the actual number of persons at any particular time that have applied and persons who have been treated with, and the process continues, Madam Speaker, for persons who would have qualified between the months of May and June. The process continues, and the details of actual figures and numbers can be had from the relevant minister with the appropriate notice, Madam Speaker.
Madam Speaker, given the Prime Minister's response, can the Prime Minister indicate when can citizens anticipate receipt of these payments in their hands?
Prime Minister.
Well, Madam Speaker, different people will get them in their hands at different times because it's a process and you're dealing with tens of thousands of persons. Those who qualify early as early applicants will receive it in their hands before those who have applied most recently.
Member for Shagona, please.
Madam Speaker, can the Prime Minister indicate whether payments of income support and salary relief grants have started?
Prime Minister.
Madam Speaker, to the best of my knowledge, persons who applied in May have started receiving those grants, but those who have applied in June, because you may recall that the persons in the contracting fraternity were added as persons to benefit, and those persons will be receiving it after those persons who applied in May. So that is underway, Madam Speaker.
Member for Shagona, please.
Prime Minister indicate whether all eligible applicants would be in receipt of their relief payments during this fiscal year?
Prime Minister.
Well, Madam Speaker, given the arrangements we have in place, all qualified applicants are expected to be paid well before the end of the year, Madam Speaker.
Member for Baratara Sanwan.
Thank you very much, Madam Speaker. Madam Speaker, having regard to the large quantum of taxpayers' money and the state's senior counsel advice to Petrotrin to immediately set aside the AV drilling arbitration, could the Prime Minister state if any such application has been filed in court?
Minister.
Madam Speaker, this matter of AV drilling, Petrotrin, and the advice is a matter that is entirely within the ambit of the Board of Petrotrin, and I'm aware that the Board of Petrotrin has received advice from a number of legal luminaries on this matter, and the board will take the appropriate action in the public interest. I am not aware that an application has been filed in the court, but that may or may not be so, Madam Speaker.
Member for Baratara Sanwan.
Thank you. Madam Speaker, can the Prime Minister indicate whether or not he's aware that one of the senior counsel's advice was that there would be a deadline for the filing of such an application, and I believe that the deadline would have passed in order to set aside this arbitration on the ground of misconduct of the arbitrators?
Prime Minister.
Well, Madam Speaker, with respect to deadlines and keeping of deadlines and advice and one senior counsel, that is a matter for the Board of Petrotrin. And Madam Speaker, if the Board of Petrotrin is seeking advice, I am sure that the advice of one senior counsel is an advice, but there may be other advice and there may be deadlines to be met, but the entire matter is a matter for the board to meet its deadline and to take on board the advice it gets from its legal service as obtained on the matter, Madam Speaker.
Member for Baratara Sanwan.
Thank you. Madam Speaker, can the Prime Minister indicate whether or not he's satisfied with the fact that the Board of Petrotrin is moving with alacrity in terms of this matter to protect the taxpayers from a judgment of almost $1 billion?
Madam Speaker, the protection of $1 billion is not the issue. The issue is that Petrotrin has lost the matter and an appeal is being considered. And the Board of Petrotrin will determine, based on the legal advice, whether or not the appeal should be pursued or whether it should seek to do otherwise. And that is not a matter for the Prime Minister. And my satisfaction is not an issue in this matter. And if you are so concerned, you should be concerned that your colleague from Siparia has put us all in this situation.
Member for Barataria-Sanon.
Can the Prime Minister indicate, Madam Speaker, whether or not a report was in fact requested from the Board of Petrotrin with respect to this particular matter?
Prime Minister.
I didn't hear the question. Could you be clearer with the question, please?
Prime Minister, is it that the Cabinet or your good office would have requested a report from the Board of Petrotrin relating to this particular matter and setting aside that arbitration?
No, Madam Speaker. This is not a matter for the Cabinet, and the Cabinet has requested no such report. What the Cabinet is aware of is that there's a matter to be addressed by Petrotrin, and Petrotrin, through its board, and there's a Minister for Petrotrin, will always in this government protect the public interest.
For Couva South.
Thank you very much, Madam Speaker. Question number 3 to the Prime Minister. In light of the recent deaths of 12 police officers within the Trinidad and Tobago Police Service who have succumbed to the COVID-19 virus, could the Prime Minister inform this House if the Cabinet has given due consideration and approval for the payment of monetary compensation similar to which are paid to the families of officers who were killed in the line of duty?
Prime Minister.
Madam Speaker, the monetary compensation for police officers are for those killed in the line of duty. For example, Madam Speaker, police officers who were shot and killed or attacked by criminals or in hot pursuit whilst on duty. Officers who have died due to COVID would not fall in this category. However, the Ministry of National Security is considering liaising with the Commissioner of Police towards a strong insurance policy for police officers that would include such other situations, Madam Speaker.
Member for Couva South.
Prime Minister, could you inform this House if the government has taken the positive step to engage the Trinidad and Tobago Police Social and Welfare Association to discuss an entitlement along the lines of what we may call a risk allowance in the context of what has happened to these 12 police officers?
Prime Minister.
Madam Speaker, I am aware that this is a matter attracting the attention of the Commissioner of Police, and I can say no more at this time.
Member for Couva South.
Prime Minister, given the number of cases in terms of police officers who have tested positive and the deaths that have occurred, could you give this House the commitment that until the end of this financial year there will be no slashing of any financial resources to ensure that there is proper and effective sanitization of all police stations within Trinidad and Tobago?
Prime Minister.
Madam Speaker, I am sure that with respect to the management of the police service, the question of sanitization of police areas of work and equipment of work would be dealt with in the manner as requested by the member, and I would expect that all managers worthy of the title in this pandemic, following the health protocols, will do that without the intervention of the Cabinet.
Member for Naparima.
Madam Speaker, question number 4 to the Prime Minister. Could the Prime Minister inform the House what data, if any, informed the decision of the government to reopen laundromats?
Prime Minister.
Madam Speaker, the data is pretty straightforward. The government has taken the position that in managing the pandemic, we reduce the exposure of elements of the national community. With respect to laundromats, Madam Speaker, it was determined that a large number of people could be serviced by a few people acting in a situation which does not expose the public. And therefore, with health protocols being observed inside of a laundry, serving in the way that they served, that it could be opened without increasing the risk to the public.
Member for Naparima.
Thank you, Madam Speaker. Prime Minister, given that data tell us that open-air activities are safe, provided COVID protocols are maintained, then why outdoor sales in restaurants are not permitted as of today?
Because, Madam Speaker, it involves, with respect to restaurants and the use of restaurants, it involves a large number of people in close quarters for a significant period of time. That is not the case in a laundromat.
Member for Afrima.
How does the Prime Minister respond to the same data allowing restaurants in Toronto, in London, England, and many cities in the US to permit outdoor sales?
Prime Minister.
Madam Speaker, the decisions made in Toronto and made in London are decisions made by the leadership of those countries on data that I don't have. I make data in Trinidad and Tobago based on what is in front of us. And Madam Speaker, I say again, the situation at a laundromat, dropping off your clothes, physically distance, and mask for a few officers working in a laundry is quite different to a restaurant where large numbers of people are involved and exposed to one another for a significant period of time. It's a different arrangement. And that is why, Madam Speaker, in our effort to open as many facets of the country as we can, while we also be cognizant of the health situation, that we will do so not just with laundromats, but with other areas, including food service, as we determine the level of risk. And it has nothing to do with Toronto or France or Germany. It has all to do with decisions made in Trinidad and Tobago by the government of Trinidad and Tobago.
Clear that the Prime Minister does not accept best practice. Why in the manufacturing of doubles, which is a family business, and large numbers of people don't congregate, why, and the sales are in the open air with COVID protocols, why not allow that given the data?
Madam Speaker, repeating it over and over is not going to change it. We are talking about the numbers of people congregating and congregated in the exercise. And of all the meals in this country, there's nothing different and special about doubles. We shut down restauranting, Madam Speaker, because it involves a large number of people. We close restaurants of all descriptions. And I don't know what is his double problem. And Madam Speaker, at the first opportunity that it appears to us that these things can be done without significantly increasing the risk to people, the government of Trinidad and Tobago will act as we are acting now.
Member for Barrett-Harrisana.
Thank you very much, Madam Speaker. Prime Minister, based on the answer given, would you not admit that the bakeries that are allowed to be open operate in a similar environment where there's a kitchen operating and persons gather in the kitchen, where you could also open restaurants, and it will be the exact same thing that is happening right now with the bakeries, and they are open?
Prime Minister.
Madam Speaker, the government looks at all opportunities to open the economy. So I am not in a position to differentiate between this bakery and that bakery, this fried and that unfried, Madam Speaker. And the advice that we use on these matters is the whole body of data, looking at the whole population, and as we use section by section, we expect, Madam Speaker, that some sections would be in and some would be coming in. And Madam Speaker, all I ask my colleagues is to stop trying to differentiate in such a way as to give the impression that certain people are being disadvantaged inappropriately while others are being favored. That is not true, Madam Speaker. I would love tomorrow to open the entire country, as your irresponsible leader is asking me to do, as though we are not in a pandemic. But it is because we are in a pandemic, and I have the responsibility of making the call, Madam Speaker, that I will make the call to protect every citizen of Trinidad and Tobago according to the advice that I get.
Thank you, Madam Speaker. Question number 5 to the Prime Minister. Could the Prime Minister inform the House what is the quantum of money paid to the law firm Al-Rari, Haynes, Suhon and Company thus far by the Office of the Prime Minister in respect of a pre-action protocol letter from the Mahasabha questioning the change in criteria for scholarships?
Madam Speaker, the quantum of money paid is zero, zilch, nada, nothing, none at this point. The matter is in the court, and at the appropriate time, a bill would be issued and a payment will be made.
Member for Naparima.
Could the Prime Minister tell us if he's aware of the procurement process used to select the firm of Alwari, Haynes, Suhan and Company?
Madam Speaker, the Office of the Prime Minister from time to time would be required to seek legal help, and they will seek that legal help through the Office of the Permanent Secretary or through the Attorney General. The Prime Minister is not involved personally in selecting any law, and if it has been done, Madam Speaker, it has been done within the realms of the appropriate public service department.
Member for Naparima.
Could the Prime Minister inform us then what procedures exist in his office for tenders such as these?
Madam Speaker, there is no procedure in my office which specifically identifies any citizen to be discriminated against or to be favored. Madam Speaker, this is a business that has involved the hiring of probably hundreds of lawyers, and I fail to see, other than a certain kind of unmentionable that has my member from Naparima, my colleague from Naparima, obsessed with what happens to a law firm in which the member's wife is a partner. And I would just suggest to my colleague, it's very unbecoming to be targeting a member's wife in that way, because no law has been broken and no breach has been met, and I'm unaware of any wrongdoing in this matter. And if you do find any wrongdoing, please let me know, and I will pass it to the appropriate authorities.
There's no personal thing. This is taxpayers' money. And could you state, I'm giving it.
Attorney General. Member for Naparima. Remember, this is question time. You are allowed to ask a question. All right? So you can ask a question, no preambles, no statements. I guess you will have another opportunity for that.
That this is taxpayers' money, and therefore it is of interest to the citizens of Trinidad and Tobago about the process in which taxpayers' money is spent.
Madam Speaker, it is taxpayers' money. I know that. But it does not mean that you have to behave like that. Oh, Madam Speaker, only recently the Attorney General read out in this House, I think, almost 200 law firms and individuals involved in providing legal asset for the, advice to the state and service. What is the obsession with the AG's wife? And you have been told from this podium that it has not been what you have been saying. I have just told you she has received no fee from it and the matter is in the court. What is your obsession with the man's wife?
Member for Naparima.
Question 6 to the Prime Minister. Could the Prime Minister inform this House as to the details of the contract with Prestige Holdings and Namdevco regarding the distribution of hampers?
Prime Minister.
Madam Speaker, Prestige offered 8 refrigerated trucks. Namdevco pays for fuel and labor. Mario's has now offered 2 trucks. These represent a significant reduction in the contracted cost of 14 trucks used in May and June.
Naparima.
Thanks. Mr. Prime Minister, could you tell this Honourable House how that came about? Was there a tendering process, a procurement process, a friend process, whatever? We need to know.
Prime Minister.
Madam Speaker, I have no knowledge other than the question being put to me, and if the member puts it elsewhere with appropriate notice, the appropriate minister will answer.
Naparima. Member for Barrett Harrison.
Thank you very much, Madam Speaker. Prime Minister, is this same company that is contracted by Namdevco the chairman of the person who was in charge of the recovery committee?
Muffled, I can't hear what you're saying.
Sorry, Prime Minister, the person who owns this company, Prestige Holding, is this the same person who was the chairman of the COVID-19 recovery committee of the cabinet?
Prime Minister.
Madam Speaker, I know Prestige Holding has shareholdings. I can't answer your question as if this is the same person or not, because I do not know, I'm not involved in the ownership of Prestige Holding. But if you file a question giving notice, we can investigate it and give you a detailed, accurate answer.
Member for Naparima.
Question 7. Given recent statements issued by the chairman of the National Insurance Board that pensions are to be reduced before persons turn 65, could the Prime Minister inform the House whether this policy position has been adopted by his government?
Prime Minister.
Madam Speaker, to the best of my knowledge, the Minister of Finance has answered this question very clearly here. I am not aware that the question reflects what the Minister of Finance has said, because what was indicated is that the matter is under consideration, and the consideration was explained, Madam Speaker. So I expect that after consideration, these developments might have a decision. But at the moment, the matter of NIB, retirement age, 60 or 65, is a matter which is under consideration, and certain consultations are underway.
Member for Naparima.
You have said, Prime Minister, that the matter is under consideration, but does the government have a policy position with respect to the elderly persons and payments such as given by the NIS?
I am not exactly sure what you're asking me.
Sheila. You have Naparima.
Minister engaged in any discussions with the Minister of Finance as regards to government's policy with respect to this matter? Or you're waiting on something to come to Cabinet?
Madam Speaker, the matter lies with the Minister of Finance, where it is being considered in consultation with all interested parties. And therefore, it is not a matter that is in front of me as Prime Minister at the moment. It may eventually get there, and it probably will get to the Cabinet. But I simply would ask the member to respect the procedures that are structural, and that policies don't exist for existence sake. Policies are there for a purpose, and if they are to be adjusted, there's a procedure for adjusting them.
Thank you very much. Prime Minister, can you indicate to this House who have been consulted so far? Who have been consulted so far with respect to this matter?
I could not. But if you put that question to the Ministry of Finance, the Minister of Finance could tell you what is being done in detail, and who and where they live, and what their phone number might be.
Urgent questions.
Member for Tabakit.
Thank you. Thank you, Madam Speaker. To the Minister of Public Utilities, in light of the nationwide power outages owing to heavy rains, could the Minister advise what urgent action has been taken to assist those residents and essential services affected?
Minister of Public Utilities.
Thank you very much, Madam Speaker. Madam Speaker, emergency crews from TNTEC were dispatched to all of the various areas affected by yesterday's inclement weather. I am advised, Madam Speaker, I'm satisfied that the utility company responded with dispatch and with alacrity, and that most of the areas affected power has been restored. Madam Speaker, for example, in East Trinidad, I'm advised that 114 area outages between yesterday and this morning, 12 crews were deployed to assist with the outages. In North Trinidad, Madam Speaker, 25 reports between yesterday and this morning. At present, all were attended. In Tobago, 4 area outages overnight. Into this morning, all were attended. In Central, 20 area outages, of which all were attended overnight. And in South Trinidad, 15 area outages, all of which were attended.
Member for Naparima. Tabakit, I'm sorry.
Yes, I'm moving on to the next question, Madam Speaker. To the Minister of Social Development and Family Services, could the Minister advise as to how many persons have applied and have been awarded emergency relief grants owing to the damage caused by the recent adverse weather?
Minister of Social Development and Family Services.
Thank you very much, Madam Speaker. Madam Speaker, on behalf of the Minister of Social Development and Family Services, thus far we have received no applications.
Member for Tabakit.
Thank you. To the Minister, I know you're answering on behalf of the Minister, but I know that my office has put forward for constituents at least 2 applications for emergency funding, so I don't know how they've received no applications. Yeah, so can we clarify that is they've received no applications?
Madam Speaker, I repeat, thus far we have received no emergency relief applications.
Member for Naparima.
To the Minister, thank you. To the Minister of Health. Given Dr. Heinz's recent statements that, quote, a large number of the cases seen in this elderly category of people was because of clusters occurring within elder care facilities, end of quote. Could the Minister indicate why the elderly at several old-age homes in Naparima have not yet been vaccinated?
Minister of Health.
Thank you very much, Madam Speaker. Madam Speaker, the issue of vaccinating persons in elderly care homes is one near and dear to me that I personally have been speaking to for months. One of the main constraints is that of receiving informed consent from either the child or guardian of these elderlies who cannot give consent on their own. To date, Madam Speaker, not to date, as of last week Saturday, I will get figures tomorrow, 1,143 persons in homes have been vaccinated. In the Southwest RHA, where my colleague is interested in, 208 residents have been vaccinated and 81 caregivers have been vaccinated. In Naparima, several have been done who have given consent. At the start of the vaccination period, 5 homes in Naparima were under quarantine, so we could not vaccinate them. They are now being cleared, and once they are cleared, they will be vaccinated. 3 are now under quarantine, so they can't be vaccinated. Our intention is to finish these homes in the next 2 to 3 weeks, depending on 2 things. 1, the COVID status of the homes, and 2, most importantly, the receipt of informed consent by either the children and or legal guardian, which continues to be the main hindrance in vaccinating these precious individuals at these homes. If my colleague could assist by talking to the homes in his constituency, we will be more than happy to work with him once consent is given. Thank you very much, Madam Speaker.
Madam Speaker, I am informed that a number of the homes in my constituency have given consent. Their families have given consent. They have been swabbed. And why are they not treated, not vaccinated, even though they have been given consent?
Minister of Health.
Madam Speaker, if the honourable member has that information, let us work hand in hand. Provide it to us, work hand in hand across this aisle. We don't need to be combative. But if you have the information, don't sit on it. Give it to us, and I will be more than happy to send in a mobile vaccination team to vaccinate these precious individuals. Don't sit on the information. Don't withhold it. Make it known to us.
Member for Naparima. Member for Naparima.
Madam Speaker, I'll give him the names in my constituency after. Then the St. Vincent de Paul in San Fernando West and the J.C. McDonald home, they are waiting. All they require is for you to come, so I've given you the information.
Again, I have told you this is not the opportunity for statements. You have any further supplemental questions?
Minister, therefore, give a date once the St. Vincent de Paul and the J.C. McDonald home will be vaccinated, given that the information has already been provided.
My colleague is sitting next to a medical doctor. The medical doctor will tell you if a home has positive COVID patients, those patients cannot be vaccinated for 3 months after. Seek advice before embarrassing yourself in the public domain. We will follow all protocols. And another thing homes can do, is reach out to the RHA. Reach out to the and once they are cleared for vaccination, once they have given informed consent, the vaccinations will be done. And we could work across the aisle in a very amicable setting to do this without the usual UNC tantrums. Thank you very much, Madam Speaker.
Member for Coover South.
Thank you very much, Madam Speaker. Question number 4 to the Minister of Public Utilities. Could the Minister inform this House as to the reasons for the sudden and inexplicable departure of the Executive Director, Chairman of the Water and Sewerage Authority, Dr. Lennox Silly, which took immediate effect?
Minister of Public Utilities.
Thank you very much, Madam Speaker. Madam Speaker, I propose to respond in this particular way by reading into the records of this Parliament the letter of resignation I received from the former Executive Director. Madam Speaker, I received a letter dated July 8th, 2021, addressed to Marvin Gonzalez, Minister of Public Utilities, number 1, Alexandra Place, Port of Spain, Trinidad and Tobago. Dear Sir, subject, resignation as Executive Director and Chairman of the Water and Sewerage Authority. I wish to inform you of my resignation from the positions of Executive Director and Chairman of the Board of the Water and Sewerage Authority due to personal circumstances. My resignation is effective today, July the 8th, 2021. I am appreciative of the experience and I thank you for the opportunity to serve in these positions. I wish you all the best in the transformation of the Water and Sewerage Authority. Sincerely, signed, Dr. Lennox Seeley.
Member for Coover South.
Could the Minister inform this House, Madam Speaker, if Dr. Seeley was constructively dismissed and there is a cover-up under the guise of a resignation letter?
Minister.
Madam Speaker, apparently the member was not paying attention to what I've just said. I've just read the letter again, Madam Speaker, and if the member wishes for me to read it again, I am more than prepared to do that. But I am satisfied that I've responded to the question that he posed to me.
Member for Coover South.
Madam Speaker, I'm fully aware how this government operates. That is why I needed to put it up.
Member, please ask the question. Ask the question.
Madam Speaker, could the Minister inform this House who now has taken charge of the management of the Water and Sewerage Authority, given the organizational structure of the entity?
Member, could you repeat that question?
I said to the Minister, could the Minister inform this House who is in charge of the management of the Water and Sewerage Authority, given the resignation of its Executive Director?
Minister.
Speaker, it appears as though the member doesn't have basic understanding of the running and the management of state enterprises in Trinidad and Tobago. There is a legitimate board in place in charge of the Water and Sewerage Authority. There is a management team in place in charge of the Water and Sewerage Authority. So I wish to allay the concerns or the fears of the member that the Water and Sewerage Authority continues to be managed by a board and by executive management.
Member for?
Could the
Member, 2 supplemental questions already.
Questions on notice?
Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, there are 5 questions for oral answer. We'll be answering all 5. Madam Speaker, with regard to the questions for written answer, you may recall that I had indicated that we were seeking legal advice. Our advice is that given the confidential nature of the information to be disclosed, we are advised that we cannot give this information, Madam Speaker. Thank you very much.
And this pertains to all 5?
Yes, ma'am.
Member for Naparima.
Madam Speaker, question number 175 to the Minister of National Security.
Minister of National Security.
Thank you very much, Madam Speaker. Madam Speaker, there is no confirmed data available in the Ministry of National Security regarding persons under the age of 18 aligned to gangs. I am further advised that the Trinidad and Tobago Police Service has not confirmed any persons under the age of 18 years as gang members. However, the Trinidad and Tobago Police Service comes into contact with persons in that age group in circumstances where they are suspects or victims in criminal investigations and in some limited circumstances. Through a social intervention approach via community police and youth groups and other means of veering young people away from that kind of life, Madam Speaker. The Ministry of National Security has acknowledged the likelihood of at-risk youths being aligned to gangs. However, the primary objective is to deter them from criminal association. As such, there are inquiries into the extent of their involvement. Gangs have been known to use persons in this category in various capacities as statures and lookouts to facilitate their criminal gang activities. Therefore, any attempt to quantify the number of persons in that age group who are members of gangs would not provide a true reflection of the situation as might possibly exist. Accordingly, the labeling in official statistics of such persons as gang members has not been the practice of the TTPS and would not be done unless and until the Trinidad and Tobago Police Service is totally satisfied that there is sufficient evidence to support such a position. Thank you, Madam Speaker.
Member for Nafrima.
Minister indicate when his government will finally proclaim the Anti-Gang Act and make it illegal to be a gang member and to recruit gang members.
That question is out of order based on the answer and question.
Given the high rate of school dropouts recently, could the minister indicate, is there any special action targeted at those individuals to help them not become prey to gang member leaders?
Minister.
While the answer to the question is yes, I consider it to be a separate issue, Madam Speaker, which I'm prepared to elucidate upon if it is properly posed to me at any time. Thank you.
Member for Nafrima.
Question number 182 to the Minister of Agriculture, Lands and Fisheries.
Minister of Agriculture, Land and Fisheries.
Madam Speaker, on behalf of the Minister of Agriculture, Land and Fisheries, I wish to advise this House that on May 3rd, 2021, the Honourable Prime Minister announced, among other COVID-19 relief measures, the continuation of the program initiated in May 2020 via NAMDEVCO for the distribution of vegetable, fruit, chicken packages to 25,000 families per month across the country. Purchase of produce, packaging and deliveries started within 4 days on May 7, 2021 to 2,000 families in 8 constituencies and continued thereafter. At a press conference held on May 10, 2021, the Honourable Minister of Finance announced an extension of the program from May to September. In pursuit of that undertaking, the Honourable Minister of Finance provided funding to the Ministry of Agriculture, Land and Fisheries of $57 million for the 5 months run of the program. With respect specifically to Part A of the question, for the purpose of dealing with farmers, NAMDEVCO has zoned Trinidad into 10 zones as follows. Zone 1, Caroni. Zone 2, Caroni South. Zone 3, St. George East. Zone 4, Nariva Mayaro. Zone 5, St. Andrew. Zone 6, St. Andrew, St. David. Zone 7, Victoria East. Zone 8, St. Patrick West. Zone 9, Caroni North. And Zone 10, St. George Central. With respect to Part B of the question, as has been done in the past, from May 3, 2021, NAMDEVCO's field officers contacted farmers in their relevant zones who are participants in NAMDEVCO's Farm Certification Monitoring Program to mitigate the potential of food safety and quality issues. Initially, for the food box program, farmers registered with NAMDEVCO under the Farm Certification Monitoring Program were given preference for the purpose of maintaining quality, verification, and ongoing monitoring. As the program expanded, Madam Speaker, these field officers and participating farmers were encouraged to share information to potential suppliers who were not in the Farm Certification Monitoring Program, but were farmers on NAMDEVCO's crop production database. This, therefore, attracted more farmers. Finally, Madam Speaker, the publicity of the successful launch and execution of the program in its first 2 weeks generated quite a lot of national interest, particularly amongst farmers. Madam Speaker, I'm pleased to report that at the end of the first 4 weeks of the program, NAMDEVCO purchased produce from 209 farmers from across the 10 zones, which is an increase from the 76 farmers who benefited in 2020. NAMDEVCO purchased in that period an amount of 7.1 million in produce, particularly to the value of 1.88 million from 72 farmers in the Plummiton to Rio Claro area, and 2.7 million from the 82 farmers in the 3 Caroni zones in central Trinidad. Thank you, Madam Speaker.
To indicate the terms, the contractual terms with these farmers, particularly with regard to payment, when payments are due.
Minister.
I'm afraid I cannot, Madam Speaker.
Member for Kabuta Manzanar.
Thank you, Madam Speaker. Question number 183 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, the Caratal village is located along the Caratal Road, which falls under the purview of the Sandy Grande Regional Corporation. And as such, the Ministry of Works and Transport does not have any work scheduled for that road. However, the road which provides the main access to the Caratal village is the Komoto Main Road, which falls under the Ministry of Works and Transport. There are 3 projects for landslip repair along the Komoto Road at the following locations. Lamppost 01, Komoto Main Road, 12-kilometer mark. Komoto Main Road, opposite the Unipet gas station, and the Komoto Main Road, Lamppost LP 300 to 301. Geotechnical investigation and conceptual designs are at various stages of progress. In addition, the St. George East District and the Highways Division has conducted routine maintenance work along the Komoto Road, such as in-house patching during the fiscal year. The routine maintenance work will continue to ensure that the road is kept passable. Thank you.
Member for Kabuta Manzanar.
Question number 184 to the Minister of Works and Transport.
Minister of Works and Transport.
Here again, Madam Speaker, again, the St. Mary Emmanuel Road falls under the purview of the Sandy Grande Regional Corporation, and as such, the Ministry of Works and Transport does not have any project listed for repair work to any bridge on that road. Thank you.
Member for Chaguanas East.
Thank you, Madam Speaker. Question number 185 to the Minister of Social Development and Family Services.
Minister of Social Development and Family Services.
Madam Speaker, on behalf of the Minister of Social Development and Family Services, at present, the capture of data by disability is not undertaken by the Ministry of Social Development and Family Services. There are 4 main non-governmental organizations that serve persons with cerebral palsy. These are the Care Helpers Organization of Trinidad and Tobago, Cerebral Palsy Society of Trinidad and Tobago, the Cerebral Palsy Association of Trinidad and Tobago, and the Caribbean Kids and Families Therapy Organization. According to data submitted by these non-governmental bodies, the number of registered adult members is 78, and for children under the age of 18, it is 104. It should be further noted that registration is voluntary, and not all persons with cerebral palsy are registered or are members of these organizations. The ministry has a long-standing relationship with the Cerebral Palsy Society of Trinidad and Tobago and has engaged them through several platforms to address their concerns. Just this week, Madam Speaker, ministry officials met with the president of the society to understand some of the current issues being experienced by the organization and its members. Following the recommissioning of the National Enrichment Center for Persons with Disabilities, located in Carlson Field, on December 12, 2018, and the renaming of this center to National Therapeutic and Resource Center for Persons with Disabilities, the Cerebral Palsy Society of Trinidad and Tobago has been using the center for the following activities. 1, as a storage site for the distribution of medical supplies and hampers. 2, hosting of monthly meetings and other miscellaneous activities. 3, fairs and the commemoration of World Cerebral Palsy Day activities. 4, as a short-term arrangement for use of the center on weekends to host events. And 5, as a facility to engage in motor skills therapy workshops with its members. Madam Speaker, it is to be noted that several faults were detected throughout the building, which necessitated remedial work to ensure that the building is safe for occupation, especially for persons with disabilities. Given the refurbishment works to be undertaken at the center, the ministry gave notice to the Cerebral Palsy Society of Trinidad and Tobago and the other organizations which were using the facility that it would be temporarily closed. Unfortunately, due to the revised public health restrictions which took effect in April 2021, efforts to complete the refurbishment work were temporarily halted. Work is expected to continue with the relaxation of restrictions on the construction sector, and barring unforeseen circumstances, it is expected that the center will be fully operational by the end of September 2021. Thank you, Madam Speaker.
Member for Shagona, please.
Madam Speaker, given all that the Minister responding has just said, can the Minister indicate whether there has been any alternative plan to assist the Cerebral Palsy Society to provide the therapy required, as you mentioned?
Minister.
Madam Speaker, next week, or in the coming weeks, the Permanent Secretary will be meeting with the Society, and those issues will be discussed.
Member for Shagona, please.
Madam Speaker, can the Minister indicate whether the Minister of Social Development and Family Services was a part of this meeting this week that took place with the Cerebral Palsy Society?
Member Farouk.
I am not able to say.
Leader of the House.
Madam Speaker. Madam Speaker, just to set the record straight with regard to the written questions that we received, I'd like to read into the record the advice, and it is as follows. I wish to advise that, and this is from the Attorney General's office, that the government is ever mindful of the need for transparency and accountability in public matters. It is equally mindful of the need to ensure compliance with the law and proper observation of the processes of law in providing information, after having addressed all issues that must be traversed. Some of the information requested is confidential, financial, and personal, relating to a large number of past and present contract employees spread out in 5 ministries. The respective ministries have engaged in required consultations with all the contract employees for the period 2015 to 2021, as contemplated in the Data Protection Act, so that proper consideration is given as to their respective positions before information is to be released. The gathering of all of the information requested is an arduous, time-consuming task, which has taken and is taking a significant period of time to collate, given the difficulties presented by the pandemic and the resultant state of emergency, inclusive of disruptions to the normal workflow of the relevant state offices and a reduced complement. Madam Speaker, in those circumstances, we are unable to provide this information at this time. Thank you very kindly.
Requests for leave to move the adjournment of the House on definite matters of urgent public importance, statements by ministers, personal explanations, introduction of bills, motions relating to the business or sittings of the House, and moved by a minister.
Prime Minister.
Madam Speaker, in accordance with Standing Order 79.3, I beg to move that the proceedings on the Constitution Amendment Tobago Self-Government Bill 2020 be resumed in the second session of the 12th Parliament at the Committee of the Whole stage.
Honourable members, the question is that the proceedings on the Constitution Amendment Tobago Self-Government Bill 2020 be resumed in the second session of the 12th Parliament at the Committee of the Whole stage. All in favour say aye. Aye. Any against? The ayes have it. Prime Minister.
Thank you very much, Madam Speaker. Thank you very much, colleagues. Madam Speaker, in accordance with Standing Order 79.3, I beg to move that the proceedings on the Tobago Island Government Bill 2021 be resumed in the second session of the 12th Parliament at the Committee of the Whole stage.
Honourable members, the question is that the proceedings on the Tobago Island Government Bill 2021 be resumed in the second session of the 12th Parliament at the Committee of the Whole stage. All in favour say aye. Any against? The ayes have it.
Thank you, colleagues.
Public business, government business, motions.
Prime Minister, are you doing this? Are you going back into the booth?
Thank you, Madam Speaker. Madam Speaker, the matter before us at this stage is a very simple and straightforward matter, and I ask for the cooperation of my colleagues. And may I begin, Madam Speaker, by just reading the notification?
Prime Minister, you'll just be assisted with the procedure.
Yes, Madam Speaker. Madam Speaker, I beg to move the following motion. Whereas Section 1, 2, 3, subsection 3 of the Constitution of the Republic of Trinidad and Tobago, Chapter 101, referred to as the Act, provides that the President shall, after consultation with the Prime Minister and Leader of the Opposition, nominate persons who are qualified and experienced in the disciplines of law, finance, sociology, or management to be appointed as members of the Police Service Commission. And whereas Section 1224 of the Act provides that the President shall issue a notification in respect of each person nominated for appointment under subsection 3, and the notification shall be subject to affirmative resolution of the House of Representatives. And whereas the President has nominated Dr. Susan Craig James to be appointed as a member of the Police Service Commission, and whereas it is expedient to approve the notification, be it resolved that the notification of the nomination of Dr. Susan Craig James as a member of the Police Service Commission be approved. Madam Speaker, this is a reappointment of a very highly qualified member of the Commission who fits the description as laid out in the text that I have just read, coming from the relevant section of law. At an earlier time, in 2018, I think it was, Dr. Craig was presented to this House as a highly qualified person and was appointed a member of the Police Service Commission with tenure from the 8th of June of June 2018, and she served until the 7th of June 2021. By notification coming from Her Excellency the President, which Madam Speaker says, it is hereby notified that I, Paul May Weeks, President, after consultation with the Prime Minister and Leader of the Opposition, in accordance with Section 122(3) of the Constitution of the Republic of Trinidad and Tobago, do hereby nominate Dr. Susan Craig James, a person who is qualified and experienced in the discipline of sociology, be appointed as a member of the Police Service Commission with immediate effect. So, Madam Speaker, what we are being asked to do here today is to take note of that and to signal our approval, because it requires affirmative approval, to a member who has served a term from June 18 to June 2021. It is a continuation of service, a renomination. I just would like to remind members of the House that Dr. Craig is highly qualified. She has been the recipient of a series of awards, local and international, for her work as a sociologist, an author, a writer, and she has served at very many levels throughout Trinidad and Tobago, serving once as a research officer with the Tobago, the Ministry of Planning and Development, way back in the 70s, and she also served as a consultant to the Tobago House of Assembly in the period 1997 to 1999. She was a consultant to the government of Jamaica in 1998. She spent a significant portion of her productive life at UWI in the Department of Sociology, where she worked from 1971 as an assistant lecturer, as a lecturer in 1974. She was head of department in 1977, 1978, and of course, she was promoted to senior lecturer in 1981. So Dr. Craig is not only a highly qualified academic, but one who has put her academic standing to the benefit of governments of the region, including our own national government and the government in Tobago, the Tobago House of Assembly and CARICOM areas. Having served for a term, Her Excellency is satisfied with her service, and I dare say, Madam Speaker, we here in this House should also be satisfied and be happy to renominate her and accept her appointment for continuation of public service on the board of on the commission of the police service, which is the Police Service Commission. So having said that, Madam Speaker, I beg to move.
Honourable members, I will now propose the question for debate. Be it resolved that the notification of the nomination of Dr. Susan Craig James as a member of the Police Service Commission be approved. Member for Couva South.
Thank you very much, Madam Speaker. As I join this debate on this particular motion that has been termed by the Prime Minister to be a simple and straightforward exercise here this afternoon. And, Madam Speaker, while the notification may be a very simple and straightforward exercise that has come from Her Excellency to the Parliament of Trinidad and Tobago, the population or the composition of the Police Service Commission is indeed a very important entity, given its importance and given its role or what is outlined in the Constitution of Trinidad and Tobago, Madam Speaker. And, Madam Speaker, from the point of view of where we sit, the very fact that the notification has come to the Parliament after consultation between the Prime Minister and the Leader of the Opposition, we take into consideration that, as I said, the Police Service Commission is an independent body which has been established under or in accordance with Section 122 of the Constitution of the Republic of Trinidad and Tobago. And in addition to that, it has a very important role and mandate to select and appoint the Commissioner of Police and the Deputy Commissioners of Police, and more importantly, to regularly and consistently monitor the efficiency and effectiveness of the functions of the Commissioner and the Deputy Commissioner of Police. And it clearly states that the members of this commission must be, in terms of, must be in the disciplines of law, finance, sociology, or management. And Dr. Susan Craig James, based on her CV, is a person who is qualified and experienced in the discipline of sociology. Madam Speaker, and we note that Dr. Susan Elizabeth Craig James was appointed previously to serve on the Public Service Commission on the 8th of June 2018. And when we look at her CV, it is a long and illustrious one in terms of what she has been able to achieve over time. And in fact, Madam Speaker, I note with a great sense of admiration when I look at her CV, Madam Speaker, that indeed she started from what we may term very humble beginnings, because it is indicated that in July of 1968, she did farm work in the south of France, picking apricots, and also that she was engaged in picking apples between July to August of 1967, after the Six-Day War of June in 1967 in Upper Galilee in Israel. And also, she was able to work for 2 weeks in a factory making Kia orange squash in Edinburgh in Scotland. So, having started in that humble manner, Madam Speaker, she has been able to work her way academically to the point where she's the holder of a master's degree in sociology and politics from the University of Edinburgh in Scotland and a Doctor of Philosophy degree from the Department of Sociology of the London School of Economics and Political Science, amongst a number of other accolades, Madam Speaker. And it is important to note, I think, Madam Speaker, given the fact that she has written extensively on Caribbean history and sociology, she was able to write, in terms of when I examine papers and publications, under number 7, Smiles and Blood, the ruling class response to the workers' rebellion of 1937 in Trinidad and Tobago, and also the evolution of society in Tobago between 1838 and 1900, a PhD dissertation at the University of London, 1955. Madam Speaker, these two works I have been able to read myself based on when I was involved as a student at the University of the West Indies, Madam Speaker. But more importantly, Madam Speaker, as we note and we appreciate what has been passed on or has been transmitted from the Parliament, from the Office of Her Excellency to the Parliament of Trinidad and Tobago, Madam Speaker, it is important that as we give this support to Dr. Susan Craig James continuing her role and work on the Police Service Commission, Madam Speaker, we hope that given what has transpired in the public domain in recent times, and I think that it has been indicated that the current tenure of the Commissioner of Police will expire on the 17th of August 2021, Madam Speaker, we hope that Ms. Susan Craig James, or Dr. Susan Craig James, will play her role, and the government will ensure that the Police Service Commission is properly constituted as the Commission goes about its responsibilities as it relates to the appointment of persons to act in the offices of the Commissioner of Police, and where applicable to, with the passage of time, the Deputy Commissioners of Police, Madam Speaker. And it is my fervent hope and wish too that the Dr. Susan Craig James will also play an active role on the Police Service Commission during her tenure to ensure that there is what we would term timely performance appraisals of the Commissioner of Police and the Deputy Commissioner of Police, Madam Speaker. And in addition to that, Madam Speaker, to ensure that there is the monitoring of the performance of the Trinidad and Tobago Police Service in the context of monitoring of the TTPS processes, systems, and initiatives, Madam Speaker, and also in terms of keeping an eye on the commitment of police officers in furtherance of the well-being of the police service of Trinidad and Tobago. Madam Speaker, we take the opportunity on this side to once again recognize the worth and contribution of Dr. Susan Craig James in her different portfolios, whether it is as an individual in the context of being a citizen of Trinidad and Tobago and the work that she has done in the service of Tobago and Trinidad at the University of the West Indies, what she has given in terms of serving on committees in pursuit of the government's work of Trinidad and Tobago, and what her expertise has also been able to give to the global community. So from this angle, we wish her a very successful tenure of office during this particular term, and we congratulate her for answering the call to serve from the point of view of national service. Madam Speaker, I thank you.
Prime Minister.
Madam Speaker, I beg to move.
Honourable members, the question is, be it resolved that the notification of the nomination of Dr. Susan Craig James as a member of the Police Service Commission be approved. All in favour say aye. Aye. Any against? The ayes have it. Minister of Finance.
Thank you, Madam Speaker.
When you speak for more than 5 minutes, I invite you to go into the speaking room.
Thank you, Madam Speaker. I beg to move the following motion standing in my name. Be it resolved that the Senate amendments to the Finance Bill 2021 listed in Appendix 1 be now considered.
Honourable members, the question is that the Senate amendments to the Finance Bill 2021 listed in Appendix 1 be now considered. All in favour say aye. Any against? The ayes have it.
Clause 4. In the proposed section 9B3, delete the word tax wherever it occurs and substitute the words tax or return.
Minister of Finance.
Thank you, Madam Speaker. This is just to make it crystal clear that the amnesty would apply to both returns that are to be filed and the taxes themselves. Penalties and interests associated with the taxes. I beg to move.
Honourable members, the question is that this House agree with the Senate on the amendments to Clause 4 of the Finance Bill 2021. Member for me out.
Thank you, Madam Speaker. Madam Speaker, just for some clarity, are we doing all the clauses at the same time or one by one?
Well, for now, we're going one by one, so we deal with Clause 4.
Okay.
I don't know if there's been a discussion among the sides, but what we have before us, the question is on Clause 4.
Okay, Madam Speaker, I have no objections on Clause 4.
I now call on the Minister of Finance. You like to move?
I beg to move that this House agree with the Senate in the amendments to Clause 4 of the Finance Bill 2021.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 4 of the Finance Bill 2021. All in favour say aye. Aye. Any against? The ayes have it.
Clause 13. In the proposed section 103A, delete subsections 1, 2, and 3 and substitute the following sections. 1. Notwithstanding any written law to the contrary, there shall be a waiver of the following liabilities. A. interest on an outstanding income tax, further tax, additional tax, withholding tax or business levy due and payable for the years of income up to 31st December 2020 and during the period 1st January 2021 to 31st May 2021, where the tax is paid prior to or during the prescribed period. B. Outstanding interest charged on any income tax, further tax, additional tax, withholding tax or business levy due and payable for the years of income up to 31st December 2020 and during the period 1st January 2021 to 31st May 2021, where the tax is paid prior to or during the prescribed period. C. A penalty due and payable on an outstanding tax or a withholding tax for the years of income up to 31st December 2020 and during the period 1st January 2021 to 31st May 2021, where the tax is paid prior to or during the prescribed period. D. A penalty in respect of income tax or withholding tax due and payable for the years of income up to 31st December 2020 and during the period 1st January 2021 to 31st May 2021, where the return is filed prior to or during the prescribed period. And E. A penalty on an outstanding income tax return for the years of income up to 31st December 2020 and during the period 1st January 2021 to 31st May 2021, filed prior to 5th July 2021, where the penalty has not been paid. 2. For the avoidance of doubt, the waiver granted under subsection 1 shall not A. Affect your liability to income tax, further tax, additional tax, withholding tax or business levy, which is due and payable under this Act, and B. Apply to any interest or penalty paid prior to 5th July 2021. 3. Where any income tax return, income tax, withholding tax or business levy remains outstanding after the end of the prescribed period, the interest and penalty which would have been payable on the return, tax or levy shall be revived and become payable as if the waiver in subsection 1 had not been granted.
Minister of Finance.
Thank you, Madam Speaker. At the outset, I want to make the point that the substantive elements of the Finance Bill 2021 remain unchanged. All we are doing here is making it crystal clear that all of the taxes that we intend to waive.
Minister, one minute, please. The Leader of the House will help you with the procedure.
Speaker. Madam Speaker, I beg to move that this House agree with the Senate in the amendments to Clause 13 of the Finance Bill 2021. And now I would like to reiterate what I just said, that the substantive form and intent and effect of the Finance Bill 2021 remains the same. What we are simply doing is making it crystal clear that all of the taxes that we have identified that would be subject to a waiver with respect to penalties, interest, and outstanding interest are clearly articulated. So that, based on advice from the drafts persons who assisted us, it was felt it was better to spell out all of the taxes. And therefore, this is the purpose of these amendments. The latter part of the amendments is simply a reintroduction of matters that are already in the Finance Act. For example, that if the outstanding taxes are not paid by the end of the amnesty period, then the taxes are revived and are due and payable. So the purpose of this amendment is simply to spell out all of the taxes. if one looks at the Income Tax Act, one will see Section 103A refers to waivers of penalties and interest. And if you look at a series of other bits of legislation, such as the Corporation Tax Act, for example, Section 19 of the Corporation Tax Act ties back to Section 103A of the Income Tax Act. So in a series of bits of legislation, once you amend 103A of the Income Tax Act, you automatically amend the Corporation Tax Act, the Petroleum Taxes Act, and so on. But out of an abundance of caution, we are simply spelling out a whole series of taxes so that there will be no argument when taxpayers approach the Board of Inland Revenue for the amnesty, the waiver of penalties and interest. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 13 of the Finance Bill 2021. Member for Miari.
Thank you very much, Madam Speaker. Madam Speaker, having listened to the Minister of Finance, the amendment really brings the clarity which I thought that was missing in the original piece of legislation. And what the Minister has attempted to do was to identify some clear boundaries and the classifications of the particular taxes where waivers would be entertained. So, Madam Speaker, waivers are good things for the citizen, especially more so for the business community that has been under a fair amount of pressure for the past couple of years. And I think this procedure, it would bring some grace and relief to those in that sector. Madam Speaker, just to add to what the Minister has said, in reading the amendments, just to bring some clarity, is that these amendments would impact not only old taxes that have not been paid, it is going to take in any taxes that are owed, any interest that is owed on those taxes, and more specifically, up till December 31st, 2020, all of the interest on those taxes owed will be waived. And I think that is important that the citizens hear and understand, as the Minister said, so that it doesn't bring arguments at the Office of the Board of Inland Revenue. Also, this waiver, it will take effect for any monies owed from the 1st of January 2021 until May 2021. So there's an extension for this year as well. So I think that is important that the citizens understand that it's taken up for 5 months of this year as well. Not only is interest being dealt with in terms of the waiver, Madam Speaker, 13(1)(c), D, and E speaks to the issue of penalties. So penalties is another charge that you pay when you owe outstanding taxes as well. So clearly the waivers, it is going to remove all the interest and the penalties as well, just for clarity. And Minister, under number 2, which I thought was a very good piece to bring in terms of the avoidance of doubt, that if you do not, from my understanding of the amendments, if you do not step forward to pay your outstanding principal amount by September 2021, then all the interest and penalty that you would have owed prior, it will become effectively due on in October 2021. You would have lost that ability to have it waived. So just to be clear to the citizenry and the businesses outside there, that we encourage you to take the opportunity to pay up your taxes and enjoy the waiver that has been afforded at this point in time. So, Madam Speaker, that's it. We can't object of any type of waivers to the citizen at this time. Thank you.
The Finance.
Well, I thank the member for that contribution. I beg to move.
Honourable members, the question is that this House agree with the Senate in amendments to Clause 13 of the Finance Bill 2021. All in favour say aye. Aye. Any against? The ayes have it.
Clause 17A. In the proposed section 54A, delete subsection 1 and substitute the following subsection. 1. Notwithstanding any written law to the contrary, there shall be a waiver of the following liabilities: interest and penalty on an outstanding tax due and payable for the years up to 31st December 2020 and during the period 1st January 2021 to May 31st, 2021, where the tax is paid prior to or during the prescribed period. B. Outstanding interest charged on a tax due and payable for the years up to 31st December 2020 and during the period 1st January 2021 to 31st May 2021, where the tax is paid prior to or during the prescribed period. C. A penalty in respect of a tax due and payable up to 31st December 2020 and during the period 1st January 2021 to 31st May 2021, where the tax is paid prior to or during the prescribed period. D. A penalty on an outstanding return for the years up to 31st December 2020 and during the period 1st January 2021 to 31st May 2021, where the return is filed prior to or during the prescribed period. And E. A penalty with respect to a return for the years up to 31st December 2020 and during the period 1st January 2021 to 31st May 2021, filed prior to 5th July 2021, where the penalty has not been paid. B. In the proposed section 54A3, delete the word tax wherever it occurs and substitute the words tax or return.
Minister of Finance.
Thank you, Madam Speaker. I beg to move that this House agree with the Senate in the amendments to Clause 17 of the Finance Bill 2021. And, Madam Speaker, this again is a tidying up provision to clear up any possible ambiguities that may exist. And again, at the end of this amendment, we are including the word return, so it will make it crystal clear that the waiver of penalties for non-submission or non-filing of a return, tax return that is, will be waived during the period 5th July to September 17th, 2021. But again, this is simply to make it clear that there will be a waiver of the following liabilities. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 17 of the Finance Bill 2021. Member for Miaru.
Thank you, Madam Speaker. Madam Speaker, Clause 17, as the Minister advised, it's procedural amendments for clarity in the legislation, and we have no objections.
Minister of Finance.
Thank you. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 17 of the Finance Bill 2021. All in favour say aye. Any against? The ayes have it.
Clause 18. In the proposed section 3A1, 1. At the end of paragraph B, insert the word and. 2. At the end of paragraph C, delete the word semicolon and substitute the word full stop. And 3. Delete paragraphs D and E.
Minister of Finance.
Thank you, Madam Speaker. I beg to move that this House agree with the Senate in the amendments to Clause 18 of the Finance Bill 2021. This deals with stamp duty. And in the original bill, there was a waiver proposed for the failure to file a return with respect to stamp duty. But there is no penalty associated with that, and there's no requirement to file a return with respect to stamp duty. So that was just an oversight on the part of the drafters. So we are just removing the section that deals with a waiver of a penalty on a stamp duty return, because that doesn't exist. There's a bit of a illogicality. So we're just taking it out, and that is why if you look at 18 at the end, the amendment, it says delete paragraphs D and E. So D and E come out, which are the ones that were waiving a penalty that really doesn't apply.
5
with respect to stamp duty returns. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 18 of the Finance Bill 2021. All in favour say aye. Any against? The ayes have it.
I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 18 of the Finance Bill 2021. Member for Miaru.
Thank you very much, Madam Speaker. As the Minister advised, Clause 18, it is purely for procedural amendments for clarity, and I have no objections.
I beg to move. Thank you. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 18 of the Finance Bill 2021. All in favour say aye. Aye. Any against? The ayes have it.
Clause 19. In the proposed section 54(4), delete the word tax wherever it occurs and substitute the words tax or return.
Minister of Finance.
Thank you, Madam Speaker. I beg to move that this House agree with the Senate in the amendments to Clause 19 of the Finance Bill 2021, and this is simply another cleaning up provision where we are making it crystal clear that the penalties with respect to late payment of taxes and late filing of tax returns, the waiver will apply to the penalties for both of those things. So instead of the word tax, we now have tax or return. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 19 of the Finance Bill 2021. Member for Miaru.
Thank you, Madam Speaker. No objections to Clause 19 at this time.
Minister of Finance.
Thank you. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 19 of the Finance Bill 2021. All in favour say aye. Aye. Any against? The ayes have it.
Clause 21. Delete the clause and substitute the following. 21(1). Section 4 and Sections 13 to 20 are deemed to have come into operation on 5th July 2021. 2. Sections 9 and 10 shall come into operation on such date as is fixed by the President by proclamation.
Minister of Finance.
Thank you, Madam Speaker. I beg to move that this House agree with the Senate in the amendments to Clause 21 of the Finance Bill 2021. Now, Madam Speaker, the second part of this amended clause was already there, and that is that Sections 9 and 10 of the Finance Bill Sections 9 and 10 of the Finance Act shall come into operation on such date as is fixed by the President for proclamation. So that is not a change per se. Those were already there, and those are the clauses that deal with the fuel subsidy. 21, it is settled law that if you are applying a benefit or you're conferring a benefit on citizens, then you can do so retrospectively without having to have a clause of this nature. That is settled law. If you are imposing a penalty on someone, then that's a completely different matter. But in this legislation, a benefit is being conferred on citizens retrospectively. However, the Chief Parliamentary Counsel advised that, again, for the avoidance of doubt, we should make it crystal clear so there won't be any argument at the Inland Revenue Division that the amnesty commenced on the 5th of July 2021. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 21 of the Finance Bill 2021. Member for Miaru.
Thank you very much, Madam Speaker. Again, the clarity is very important. This particular section, clause, Madam Speaker, 21, and we have no objections.
Minister of Finance.
Thank you. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 21 of the Finance Bill 2021. All in favour say aye. Aye. Any against? The ayes have it.
New Clause 20. A. Insert after Clause 19 the following new clause. Chapter 7701 amended. 20. The Miscellaneous Taxes Act is amended in Section 62A by inserting after the word taxes in every place where it occurs the words penalties. B. Renumber the clauses accordingly.
Minister of Finance.
Thank you, Madam Speaker. I beg to move that this House agree with the Senate in the amendments to new clause 20 of the Finance Bill 2021. And, Madam Speaker, the Miscellaneous Taxes Act is exactly what its title implies. It covers taxes such as the Green Fund, for example. So we wanted to make it clear again that we were waiving any penalties with respect to payment of Green Fund levy and other similar taxes that are covered by the Miscellaneous Taxes Act. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to the insertion of the new clause 20 of the Finance Bill 2021. Member for Miari.
Thank you, Madam Speaker. Madam Speaker, in closing, we on the opposition can find no objection in any action by this government that will bring, will ease the pain and suffering of both the business community and the working population, especially in these times, Madam Speaker. And we do hope that that the citizenry take the opportunity to use this facility as brought on by the Finance Minister. Thank you.
The question is that this House agree with the Senate in the amendments for the insertion of the new clause 20 of the Finance Bill 2021. All in favor say aye. Aye. Any against? The ayes have it.
That's it.
So, Attorney General, 5 minutes. Yes. Okay. Attorney General.
Madam Speaker, thank you. Madam Speaker, I beg to move the following motion standing in my name. Be it resolved that the Senate amendments to the miscellaneous provisions, Special Reserve Police and Police Complaints Authority Bill 2021, listed in Appendix 2, be now considered.
Honourable members, the question is that the Senate amendments to the miscellaneous provisions, Special Reserve Police and Police Complaints Authority Bill 2021, listed in Appendix 2, be now considered. All in favor say aye. Aye. Any against? The ayes have it.
Clause 3A. In subparagraph A3, A, insert the word open quotation marks before the words serious police misconduct means. B, delete the words 136 and replace with the words 136 or. And C, insert the words close quotation marks, semicolon after the words disrepute and. B, delete subparagraphs D1 and 2 and replace with the following new subparagraphs. 1. Paragraph D, by inserting after the words police service the words the Special Reserve Police, the Municipal Police Service. 2. Paragraph E, by inserting after the words police service the words the Special Reserve Police or the Municipal Police Service. C. Delete subparagraph E2 and replace with the following new subparagraph. 2. Inserting after the words police service the words the Special Reserve Police or the Municipal Police Service. D. In paragraph G, delete the proposed new section 44A and replace with the following new section. Authority to be provided with written statement or update. 44A1. The Commissioner, Assistant Commissioner, Director of Public Prosecutions, or the Commission shall, within 3 months from the date the authority makes a recommendation under Section 44.2, provide the authority with a written A, statement with reasons on any action which has been taken or is proposed to be taken or not taken in respect of a recommendation, or B, update on the progress of a matter which is the subject of a recommendation. 2. Where the authority has not received a written statement or written update in accordance with subsection 1, A, the authority may make such a further request for the information as may be necessary, and B, the Commissioner, Assistant Commissioner, Director of Public Prosecutions or the Commission shall, without delay, provide the required information. 3. Where the authority has received a written statement or written update in accordance with subsection 1 and requires further information in respect of a matter, A. The authority may make such further requests for information as may be necessary, and B. The Commissioner, Assistant Commissioner, Director of Public Prosecutions, or the Commission shall, without delay, provide the required information. E. Delete paragraph H and replace with the following new paragraph H. In section 48, in 1, subsection 1, by deleting the words "and the Commissioner" and substituting the words "the Commissioner or the Assistant Commissioner." And 2, subsection 2, by deleting the words "or the Commissioner" wherever they occur and substituting in each place the words "the Commissioner or Assistant Commissioner."
Attorney General.
Madam Speaker, I beg to move that this House agree with the Senate in the amendments to Clause 3 of the Miscellaneous Provisions, Special Reserve Police and Police Complaints Bill, Authority Bill 2021. Madam Speaker, the amendments before us are straightforward. We wish to bring clarity to the definition of serious police misconduct. In those circumstances, we wish to put the regulations at the Trinidad and Tobago Police Service, Chapter 1501, in the alternative, Section 136 or Section 150, subsection 2. Secondly, insofar as we now have 3 categories of officers being supervised, that is the regular Trinidad and Tobago Police Service, Special Reserve Police officers, and now the Municipal Police Service, we wish to specifically spell that out, and therefore the amendments circulated in paragraph B become germane. We also find that same rationale for the amendments at paragraph C as circulated, again specifying the differences between police service, municipal police, and special reserve police. It is similarly for that same reason that we make the recommendations in paragraph C. At paragraph D, we received a submission coming from honourable members on the independent bench as to the need for including the Director of Public Prosecutions to tell what is happening to the public via the Police Complaints Authority. And also this was a recommendation coming from the Law Association. We found merit in that, and therefore we have provided an obligation on behalf of not only the Commissioner of Police to say to the PCA what is the status of matters, but also from the Director of Public Prosecutions. The last amendment at paragraph E is again consistent with those in paragraphs B, C of the amendments as circulated, merely bringing the clarity to the respective roles of Commissioner, Assistant Commissioners across Police, Special Reserve Police, and Municipal Police. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 3 of the Miscellaneous Provisions, Special Reserve Police and Police Complaints Authority Bill 2021. Member for Napari.
Thank you, Madam Speaker, Madam Chair. We return today to comment on the changes being made to the Special Reserve Police and Police Complaints Authority Act. Madam Speaker, the PCA is the body responsible for investigating complaints made against police officers, SRPs, and municipal police, and making recommendations to the Commissioner of Police, or DPP, for appropriate action. Madam Speaker, I'm glad to see that the Attorney General took my comments into consideration during my contribution to this debate on March 5th, 2021. You see, Madam Speaker, the original bill only provided for the Commissioner or the Assistant Commissioner of Police to provide the PCA with an update on the progress or outcome of the PCA's recommendations. And I asked the question in March, where is the equivalent requirement for the DPP? Today, the arrangements before us now state that the DPP shall provide an update on the progress or outcomes of recommendations made by the PCA. And this is an improvement, Madam Speaker. We can all agree that the Attorney General's legislation is always improved when he listens to us on this side. The records will show that. Updates from the DPP office are necessary provision. We recall when the PCA director Mr. West, Director West said, and I quote, "After we go through the investigations and we have the evidence, many times when we give our file to the DPP, he is busy and there is some delay. He has staff constraints, he has financial constraints," end of quote. When a matter is referred to the DPP from the PCA, it would usually be in regard to allegations of serious misconduct by police officers. It is important that these matters not be forgotten, delayed, or pushed aside indefinitely. Our law enforcement must be above reproach. Therefore, there ought to be swift resolutions of complaints made against them. Further, the amendment will now grant the PCA the power to request a written update from the Commissioner of Police, the Assistant Commissioner of Police, or DPP if none is received after 3 months or if they require further updates. While these changes are welcome, it is, in our view, it is still not yet enough to improve transparency and efficiency with respect to resolving complaints against our police. The government must also consider policies which will reduce the number of complaints made against police officers.
Member for Naparima, remember, this is a very limited debate. It's limited to what is before us. And it's not an open general debate that on total policy as originally obtained. Okay? So that I realize that you're going on to something else that is not contained here and you're confined to what is here before us. All right?
And I'm commenting on what exists here. And we're saying that it could be improved a little, even though we support it as it stands. I'm sure that is within the remit of a discussion of what the amendments that have been.
I have tried to guide you, and I hope you will comply with guidance.
Madam Speaker, the only thing I'd like to say before closing is that we feel that there should be something that exists in the Ontario Special Investigation Units, that where citizens can review the status of complaints they have made against the police. But this is an improvement, and we support it. We are just of the view that more needs to be done. Thank you.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I wish to thank the Law Association of the Republic of Trinidad and Tobago for the recommendation that it gave with respect to the inclusion of the Director of Public Prosecutions, and for the Director of Public Prosecutions constantly ensuring that we get to a better place. I therefore do not give any of the paternity for these amendments to the Honourable Member for Naparima. What I can say, Madam Speaker, is that we are definitely in a better place. I find it quite conspicuous that these amendments coming before us now, with recommendations coming from a very agitated opposition, didn't come at all in the 5 years and 3 months that they had supervision of the Police Complaints Authority to even make a scintilla of effort to cause the laws to be amended. So, Madam Speaker, there's nothing else to say other than we will continue to press on and undertake the work of the people of the Republic of Trinidad and Tobago, and I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to the Clause 3 of the Miscellaneous Provisions Special Reserve Police and Police Complaints Authority Bill 2021. All in favour say aye. Any against? The ayes have it.
Bills, second reading.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Quarantine Act, Chapter 2805, be now read a second time. Madam Speaker, before us is a very, very short bill with a very specific purpose. This bill is 2 clauses in length. The first clause is to cite the Quarantine Act as being amended by the Quarantine Amendment Act 2021. The second clause is to cause an amendment to 2 sections of the Quarantine Act. Madam Speaker, the relevance of this debate is squarely tied into the reopening of the economy, and very importantly, it's tied into the reopening of the system of admissions via airports and seaports in this country, because the Quarantine Act is what prevails there. Madam Speaker, the Quarantine Act is an Act number 19 of 1944, It's a robust piece of law that has served us well. It was amended by Act Number 29 of 1945 and Act Number 31 of 1978. We operationalized certain aspects of the Quarantine Act very recently when we issued the Quarantine Act Chapter 2805 order, and that was done under the hand of the Chief Medical Officer on the 31st of January 2020, where we effectively located the coronavirus COVID-19 as subject to supervision by the Quarantine Act. Today, Madam Speaker, this country, having in its operation the state of emergency regulations made pursuant to the Constitution. Secondly, the public health regulations made under the Public Health Ordinance. And thirdly, the Quarantine Act. We must today ensure that in the reopening of the borders, that regulations that are offered under the Quarantine Act and that the information which you provide, very importantly, at border entry, that you are bound to be aware that you must tell the truth, you must cooperate, you must ensure that the officers acting under the Quarantine Act are given full information that is accurate and full cooperation. Therefore, we do two things today. Firstly, we ask for an amendment of the Quarantine Act in Clause 4 of the Quarantine Act. We are asking, in Clause 2 of the amendment bill, we're seeking to amend Section 4 of the Parent Law, and we are saying, even though there is a power to make regulations, we need to include that the regulations are subject to a consequence. Breach of the regulations, we ask, be met with exactly the same breach of regulations for public health, and that is, if you breach the regulations, you are subjected to a fine of maximum $250,000 and maximum imprisonment for 6 months. I should add, Madam President, Madam Speaker, that the law was amended, the Interpretation Act was amended last year, such that breaches of the interpretation of regulations under the Interpretation Act also now stand at $250,000 and 6 months. Therefore, we are harmonizing the breach of subsidiary legislation under this particular act with what we have done in the Interpretation Act. At Clause 2, the second part, we amend Section 7 of the Act. And we propose, instead of a fine of $6,000 and 6 months, we're asking for the breach of the Act to be at higher than the regulations at $350,000 and imprisonment for 1 year. Why do we do that, Madam Speaker? Because Section 7 of the Quarantine Act is where any person who refuses to answer or knowingly gives an untrue answer to any inquiry made under the authority of this Act, or intentionally withholds any information reasonably required by him by an officer or other person acting under the authority of this Act, or knowingly furnishes to any such officer or other person any information which is false, or B, refuses or willfully omits to do any act required of him, etc., or to carry out a lawful order or instruction, or C, assaults, resists, willfully obstructs, intimidates any officer, etc., is guilty of an offense, effectively. So what we are doing, we are ensuring that with the IT operationalization, where you log on, you give information to the government of the Republic of Trinidad and Tobago in your repatriation process, in your coming into this country, whether by seaport or airport, that the penalty of law for telling an untruth or not cooperating or not obeying lawful instruction is met with by more than $6,000, which is what the law currently says, and instead it goes up to a maximum of $350,000 and one year, Madam Speaker. That is at Clause 2 of the bill. This is proportionate law. It's necessary. It is something that we wish to do with immediacy so that we can ensure that we are in time for the reopening of borders as announced by the Honourable Prime Minister, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Quarantine Act, Chapter 2805 be now read a second time. Member for Faisabad.
Thank you very much, Madam Speaker, for an opportunity to contribute to this bill, which is the Quarantine Amendment Bill 2021, seeking to amend the Quarantine Act, Chapter 2805. Madam Speaker, whilst I agree, it's a very short bill, but it's a very critical bill as well in the battle versus COVID-19. And my remarks really will be confined to just a few concerns regarding the fines, Honorable Attorney General, as well as to seek clarification. My understanding is that, of course, we're speaking to the protection of the SARS coronavirus 2 and its variants from coming into Trinidad and Tobago by way of the opening of the borders. And of course, this is a very important protection that we have to put in place, keeping in mind, of course, that our current numbers are still high, and therefore it is even more critical. So if we look at the explanation, the explanatory note where Clause 2A is amending Section 4 with the insertion of a new subsection 3 to impose a penalty of a fine, $250,000, and to imprisonment for 6 months for any contravention of the regulations, and those regulations have been well spelled out. And of course, Section 7 is the one that may cause a little bit of concern in terms of the fees, which some may consider exorbitant. They're certainly prohibitive. And the Attorney General mentioned that he believes it's proportionate. One can understand, and I certainly would want to, of course, the fines are such that you want to prevent anyone, any offenses committed. So, Madam Speaker, if I may, just to look at the Section 7 in a little bit more detail, some of these offenses could be construed as purely subjective, and therefore one has to depend sometimes on the interpretation of the immigration and possibly customs officers at the airport. I also want to make the point that some sort of training will be required if that has not already been done in terms of dealing with these regulations. And of course, most importantly, to ask the question and to have the assurance that those who will be dealing with returning passengers at the airport when we open on the 17th of July, in terms of they'll be fully vaccinated, both immigration officers and the port health officers who are so important in this whole process. Madam Speaker, the Attorney General mentioned the issue of the IT operationalization. Again, very important. For this process to run smoothly, you want to ensure that you have limited contact, and a lot can be done through IT. And I would want to ask, because in other jurisdictions in the Caribbean, you have software applications. For example, Barbados has an app called the BIMSAFE app, where you can upload your information before you travel into the country. And that makes the entry process much simpler, again, with minimal interaction and saving contact time. And Jamaica also has one called the JAM COVID-19, and therefore the question is whether in Trinidad and Tobago we can expect to see a similar app before the 17th of July, whether something has already been developed, and maybe we can get some clarification with regards to that. And also interesting, and I hope that we can get to this point, Madam Speaker, is the fact that sometimes these apps are linked to a tracking device, which makes the surveillance of persons returning much easier to and safer to follow. Madam Speaker, this is linked, and if you may permit me, I just want to raise one issue, because I know this is linked to the Ministry of Health quarantine protocol, which has been issued, and I trust that this has already been uploaded on the websites and is available to citizens who are intending to travel abroad. And I just want to go to the category 3 with regards to fully vaccinated individuals, because Section 7 speaks to given information and the accuracy of information and so on, Madam Speaker. And I think it's very important that those who are traveling are very clear as to what sort of information they have to provide and the bona fide of this information. So we speak of the PCR test being 72 hours prior to arrival. So that's important. I also wanted, if I may quote from the Ministry of Health document, Madam Speaker, with regards to category 3, it says a fully vaccinated individual is defined as a person who has received the required number of doses of a WHO-approved vaccine and has been 2 weeks post the final recommended vaccine dose. And Madam Speaker, I just raised that point because although we understand that the two doses can be 2 doses of the same vaccine, there's a situation that can arise in terms of those returning, and with regards to what is called a mix and match vaccine. And this is a practical situation, Madam Speaker, because, and if I may just quote briefly from a BBC News Online report, June 28, 2021, entitled, Mixing COVID Jabs Has Good Immune Response. I don't want to intend to go into the immune response. It's not about this, Madam Speaker. But essentially what has happened in the UK, there's been a study of close to 1,000 persons where they've been given 1 vaccine followed.
Order 48-1, most respectfully.
Okay, so Member for Faisabad, while I understand what you're trying to do, it is really going outside the scope of what is there.
Madam Speaker, and if...
So I'll just ask you to wrap that up and go on to a point that really is directly related to this.
Speaker, I'm just taking this because it relates to the accuracy, and I'm just, AJ, if you will just permit, it relates to a practical application where I just wanted clarification as to whether if someone comes in with a mix of vaccines, whether that person will be considered fully vaccinated. So by example, there are situations where they have AstraZeneca and Pfizer.
And as I said before, Member for Faisabad, while I'm somewhat sympathetic, what you're trying to find out does not form the subject of this debate. Okay? So please go on.
Thank you, Madam Speaker. So, Madam Speaker, as I conclude, I would just want to say that whilst we understand the need for these amendments, we would just want to, express the concern about the fines, and perhaps ask the AG if he can maybe look at revising those fines, and also to ensure that the other steps in the battle needed to be stepped up in terms of the vaccinations. And with those few words, Madam Speaker, I thank you.
Minister of Energy and Energy Industries.
Have to go in there.
Once your contribution exceeds 5 minutes, I'm inviting you to go into the
5.5 minutes. Thank you very much, Madam Speaker. Madam Speaker, I have joined the debate just to add some necessary clarity to what is going on the government's side with respect to some of the things some of the matters raised by the previous speaker, the member for Faisabad. And more will be spoken about this in the coming days. But just to give the population, through you, Madam Speaker, an insight and to assure the population that the government continues to be a responsible government, continues to be ahead of all that was just said by the member for Faisabad, and to outline very briefly, without getting into any level of detail, what exactly is happening with respect to the border reopening. The efforts being made for the reopening of the border, which the Honourable Prime Minister has announced, which will take place next week, Saturday,
are being driven under the chairmanship of the Office of the Prime Minister, and that's the reason why I'm able to speak to it. We have all of the necessary ministries in play. This ties into what the member for Faizabad was saying, and to assure the population we are building out. And we got actually got a demonstration this morning. That app and that IT platform that is going to capture all of the data. So persons prior to coming to Trinidad and Tobago will be required to upload the essential information to get a travel certification, which is really a green light that they can then board the plane within that 72-hour period. It is very similar to the jurisdictions you've referred to. We're using the same people who built it out in Jamaica, St. Lucia, Grenada, Turks and Caicos, and British Virgin Islands. So it is the identical platform, but of course, with our necessary requirements, because we are going with a vaccinated versus an unvaccinated line of entry into Trinidad and Tobago. This bill that the Attorney General has piloted and what he's leading here today is to fit in to that platform, because people who are required now to upload their vaccination documents, proof that you've been fully vaccinated, if you provide false information, these are the fines that are going to be applied to you. You're also required to have a 72-hour negative PCR test. You have to upload that as well into this platform to get the green light that you can take to the airline counter to enter Trinidad and Tobago. That is also going to be here, that if you provide false information, you're going to be now subject to this increase in fines. This increase in fines, apart from the conformity that the Attorney General referred to, Madam Speaker, is all actually being implemented because we have been working on this IT platform, which is going to be called TT Travel Pass, to enter Trinidad and Tobago. So have no fear, the government is very aware of it. We've been working on it. We have all of the IT professionals. We've had the Ministry of National Security, Immigration. We've had input from, is being driven as well by the Ministry of Public Administration and Digitization. And this will be launched very shortly in time for next weekend. And we will have a full conference to be able to explain to the population and the world at large how this is going to apply. This is one of the necessary pillars of that, because we want persons to know, Madam Speaker, do not falsify documents, do not provide us with false information with respect to something as serious as whether you are fully vaccinated or not before you enter Trinidad and Tobago, something as serious as do you have your negative PCR test 72 hours before entering Trinidad and Tobago. So this increase in fines is very welcome, and it is to send the signal and to implement exactly what the Honourable Prime Minister spoke about 2 or 3 weekends ago when he indicated that we're going to be opening the borders. He indicated that persons must provide proper information, and if anyone provides false information, they will be hit with the requisite fines and penalties. Also, what I can point out at this stage, Madam Speaker, is the unvaccinated nationals who come into Trinidad and Tobago. As you know, they're going to be required to go into quarantine, paid for quarantine, state-supervised quarantine. These fines will also go towards that understand you're being allowed in, you're a national, but you're unvaccinated. You have to go into quarantine. This platform that we're going to launch will require all of the information. You have to upload that you've already paid for transportation, you've paid for your hotel accommodation, paid, not booked, and then you go into a certain tunnel that will take you all the way from the time you land in Piarco to the requisite hotel. So these fines, Madam Speaker, tie into that anyone who attempts, God forbid, to try and break the quarantine or beat the system, they're going to be hit with these heavy fines and the increase in the penalties, which include imprisonment. So to assure the population, and that's why I intervened, and I thank the member for Aruka Maloney to allow me to intervene in this debate, to just address these issues. The system has been built out and is about to be launched. So, Madam Speaker, this ties into that whole system. Thank you very much.
Member for Cubasau.
Thank you very much, Madam Speaker. As I join this debate on the Quarantine Amendment Bill 2021 to make a very short intervention, because I have noted the comments of the Minister of Energy and Energy Affairs, the member for Port of Spain North, St. Anne's West, and also the Attorney General, and probably the most appropriate person to make the intervention on the government side probably would have been the Minister of National Security. And this piece of legislation that is before this particular House, Madam Speaker, in addition to the amendment bill, it is important to note that there are also the Quarantine Maritime Amendment Regulation 2021 that was dated the 4th of February 2021 under legal notice number 111 of 2021, and the Public Health number 17 regulations dated the 29th of June 2021 through legal notice 186 of 2021, and the Ministry of Health quarantine protocol for passengers entering Trinidad and Tobago, effective the 17th of July 2021, Madam Speaker. And Madam Speaker, the Minister of Energy and Energy Affairs commented that on the whole question of the online platform to upload PCR tests and vaccination information, and indicated that it will be launched very shortly, and it will provide you with the opportunity to upload your transportation information, your hotel information, and so on. And the question that should be asked, because we live in the digital age and platforms crash from time to time, Madam Speaker. I could remember when the move was made to assist our primary school and secondary school children and so on in this very said pandemic environment. Within minutes of the online platform being launched, it crashed. And I hope that the minister indicated that they was using an app that was similar to Jamaica and the British Virgin Islands and so on. But I hope that somebody on the government side can provide some sense of comfort that it will not crash within minutes of launching this particular online platform. And probably in his winding up, the Attorney General could guide us in terms of whether this particular arrangement and online platform, is it being done wholly and solely by the Ministry of, is it the Public Administration and Digital Transformation, or is it private entities involved also? I do not know. We are seeking the information in relation to the provision of this particular service. And if indeed a private entity is involved, will the Attorney General or someone on the government's side provide the necessary details as it relates to the costs, the terms and conditions, and so on, Madam Speaker. And also, if the online platform, when it is launched and so on, what is the response time or the turnaround time for persons who upload their information onto the platform in terms of getting the desired feedback from the online platform and so on? Because we have been told of horror stories where persons were seeking exemptions to come in to Trinidad and Tobago.
My learned colleague, I'm sorry to interrupt on 48.1, respectfully.
Okay, so member for Cuba South, I guess you would say you're responding to something that the Minister of Energy and Energy Industries raised. But not everything that is said, it may be very peripheral, is allowed to be responded to in the depth and become relevant. So I would agree with the Attorney General that the realm you're going into, for the purposes of what is the substance of this debate, is offending Standing Order 48.1.
Thank you very much, Madam Speaker, and I'm guided. And Madam Speaker, in relation to the proposed amendments, and more so with respect to Section 4 and Section 7, because there is an insertion of a new Section 4 to provide that the breach of the regulations under the Quarantine Act shall attract a penalty of $250,000 plus 6 months, Madam Speaker. And in addition to that, the fines of $350,000 plus 1 year imprisonment, Madam Speaker. We, on this side, we are of the opinion that these penalties which are being imposed or which is being proposed by the government are really grossly disproportionate to the offenses, Madam Speaker, because we believe that assaulting, resisting, willfully obstructing, or intimidating an officer can be punishable. Well, we are asking the question and taking into consideration that it will be punishable up to $350,000 plus 1 year. And we recognize that the judicial discretion will apply in terms of the range of the penalty. But at the end of the day, the fact that this penalty is prescribed in a primary piece of law will indicate to the court that the Parliament intended a higher punishment under the Quarantine Act. For example, the same offense under the Summary Offences Act, Madam Speaker. And as my colleague in the other place pointed out, Senator Jayanti Lakshmi-Dayal, she pointed out that these fines are an increase of almost 5,000%. And the punishment is supposed to be proportionate to the crime. And Madam Speaker, while we agree that stricter penalties are indeed required as a deterrent, and also to ensure that the country is protected against the further spread of this virus by incoming passengers, some degree of balance needs to be employed as it relates to the application of these fines, Madam Speaker. And one final point, Madam Speaker. I know my colleague, the member for Faizabad, touched on this particular issue, but I think that is important for us to underscore the need for the health and safety protocols to be enforced at the ports of entry to ensure that there is proper social distancing, there is proper sanitization stations and so on, Madam Speaker, and also for the necessary personal protective equipment. We cannot continue to underscore these points and to ensure that there is separation of cubicles and so on. The appropriate safeguards are taken into place so that the immigration officers, the customs officers, and all personnel from the point of view of public health and airport authorities, staff and so on, can play their particular role as it relates to when the borders are fully open for the citizens of Trinidad and Tobago and all incoming passengers. Madam Speaker, I thank you with these few words.
Member for St. Joseph.
Thank you very much, Madam Speaker, for allowing me the opportunity to make a short intervention, much shorter than I originally envisaged, but in the spirit of the way the debates have been going. Madam Speaker, the matter before us today concerns amendments to the Quarantine Act, Chapter 2805, purpose of which is to prevent and contain the spread of infectious diseases. Madam Speaker, quarantine normally means restrictions placed on the entrance to and the exit from the place or premises where a case of communicable disease exists. Madam Speaker, the opposition, I need to respond to a couple of points raised by the opposition. One has to deal with what they are claiming to be the disproportionate measures. May I indicate, Madam Speaker, that these measures are in fact proportionate, and I will go on to give a couple of examples. Madam Speaker, one can look at what is happening right now in the United Kingdom. This is just to respond to the position being put forward that these measures are disproportionate. In the United Kingdom, if a traveler breaks the COVID-19 regulations according to their new rules, they face a £1,000 fine and a £2,000 fine for those who fail to take a mandatory test. Also, a further 5,000 fixed penalty notice if you do not comply with their COVID-19 restrictions. The Secretary, Matt Hancock, also announced that travelers having to stay in quarantine hotels in England, which is similar to what we are asking for to do, will be charged £1,750 for their stay. And Madam Speaker, what could be more disproportionate according to the UNC? Those who fail to quarantine in a government-sanctioned hotel, which is the same thing we are asking for, face 10 days in jail. Oh no, in a government-sanctioned hotel for 10 days, face a fine of £10,000. This is how serious governments around the world are taking this. But it is only here we don't recognize this. Madam Speaker, I want to respond to two issues raised by the member of Faizabad. One, he was asking about the vaccination for persons at ports of entry. I can say that we have allocated almost 800 to 1,000 doses already to that, and that vaccination process has begun and will conclude next week. The member also asked about the mixing of vaccines, and I'm glad you raised it because it was mentioned last week.
Minister, I think at that point I had stopped the member for Faizabad and ruled on Standing Order 48-1.
So if it's irrelevant, but there is a policy in place of it. Madam Speaker, coming back to the quarantine, coming back to the amendments being looked at today. Why are these amendments so important? The WHO lists 10 threats to global health. 1, the threat of a global influenza pandemic. While this is not influenza, it is similar. And 2, vaccine hesitancy. Madam Speaker, these amendments are crucial if we don't learn throughout the course of history what has happened if we do not manage and put fines in place to deal with these things. The plague of Justinian, Black Death, smallpox, cholera, TB, HIV, AIDS, dengue, SARS, MERS, H1N1, Spanish flu, and now COVID demand that we take serious action, and I want to rise in support of the amendments so put forward by the Attorney General to amend Section 4 and to amend Section 7. These amendments are crucial, very crucial, as we approach the opening of the borders on July the 17th. So from the Ministry of Health and from my position, I am in total support of these amendments. Thank you very much, Madam Speaker.
Thank you, Madam Speaker, for allowing me to join this debate. So, Madam Speaker, today we are debating the Quarantine Amendment Bill of 2021. And the major issue with regards to this bill is we want to prevent the spread of new variants in Trinidad and Tobago from persons that may be entering our country when the borders are opened. And the major variant that we have currently in the international arena is the Delta variant, which is a clear and present danger to Trinidad and Tobago, because currently we are mostly with the Brazilian variant, which is the dominant variant in Trinidad and Tobago of the coronavirus. Now, that being said with regards to the Quarantine Amendment Bill, I would like to say that our quarantine processes in Trinidad and Tobago seems to be very safe. I did not know of one case where coronavirus was spread in our general population because of someone that was in our quarantine system. The Brazilian variant obviously entered Trinidad and Tobago through our porous borders.
Standing Order 48-1, please.
So, Member for Caroni East, you've just begun. I'll give you some guidance. Remember, this is not really a bill about Corona or COVID-19. It's not a bill about quarantine facilities in general. And while some of these things may be sort of secondary, what we're dealing with is fine. So I'm giving you some guidance and a little leeway in the hope that you will zero in on the provisions of this very short bill. Yes.
So I will go to Section 4 of the Act. And under Section 4, subsection 1, Part B, it says that the spread of infection with regards to any person that may leave a place or a ship or aircraft. And I was, in the closing of the Attorney General, I'd just like to ask if this would pertain to persons under the age of 18, as well as persons that are much younger than that, let's say under 7 or 8 years of age. With regards to the major issue here of the increase in fines due to the falsification of documents, it was my opinion, documents can be easily falsified. So if we have a PCR test, which is a paper document, someone could easily scan that document, perhaps falsify it and insert their name and then upload that to the online system. I was thinking, why don't we have the certified labs that are certified by the FDA in the United States to submit that information to a government portal? And would that not be a more secure system of having a PCR test for validation in Trinidad and Tobago? If we have to increase the fines to such an amount that we are afraid of variants coming into our system here in Trinidad and Tobago, wouldn't that be a better system? Under subsection 2 of section 4 as well, there's the CMO is allowed to detain persons that may leave an aircraft. You know, I was just wondering, in regards to this detention, how long would a person have to be detained and where would they have to be detained? With regards to section 7,
I take it you're moving on from subsection, because remember, the only clauses we have here are 4 and 7, and not 4 in its entirety, an addition of a subsection 4. All right, so I was rising because I realized you were dealing with 2 and 3, which are not the purpose of this bill.
That was under section 4 as well, Madam Speaker. That was subsection 2.
And just as guidance for going on, subsection 2 dealt with not 4 in its entirety, but the insertion of a new subsection 4. Okay? So I'm giving you some guidance going on to 7. It's not 7 in the entirety, all right? But certain parts of 7. Okay?
With regard to section 7, we have any person that refuses to answer or knowingly gives an untrue answer to any inquiry or intentionally withholds any information reasonably required by them or knowingly furnishes to any such officer information which is false. So as the MP for Couva South was saying, this is very subjective, and perhaps we could have more training for our police officers that may have to interact with these individuals. With regards to section B, we have persons that are willingly omits an act or willingly omits or carry out an instruction or condition made. And then we have assaults or resists in section C, an officer or person acting under authority of this act. So it will be important, Madam Speaker, with regards to section C as well, that officers are trained in dealing with situations such as this, where they may have to respond to a person under the Quarantine Act. And in terms of situations where somebody may become aggressive, as well as officers should be trained in dealing with biohazards. if a person...
Madam Speaker, standing 48-1, please. Oh, gosh.
Yeah. All right, just be a little patient. In terms of the member for Caroni East, while you're reading out what the offense is, what this bill is about the fine. Okay, so as I said before, while people may have been given leeway to say certain tangential things, they don't become the substance of the debate. All right? So I do agree that those matters are irrelevant under Standing Order 48.1.
Okay. As well, Madam Speaker, with regards to the fines under Section 8, what it says is that the minister may direct any part of a fine recovered in respect of any offense of this act to be paid to any person who has given information leading to the conviction of the offender.
Again, if we look at it, we're not dealing with subsection 8. All we have before us is subsections 1 and subsection 2 of section 7. So basically, that is what is the gravamen of this debate.
So just in closing, Madam Speaker, I just wanted to say that with the increase in fines, persons may be victimized because of the amount of money involved. And, it's a situation that we should consider. In my opinion, the fines are excessive. It's a little too excessive. Our quarantine system is very secure. It has worked well for over 1 year, and the fines are too excessive. Not many persons can pay that fine. In a situation where someone offends these clauses, it will basically be to go to jail. So they are not proportionate, Madam Speaker, in any way, and more consultation perhaps may be necessary to have more proportionate and more appropriate fines. And with that, Madam Speaker, I thank you.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I thank honourable colleagues for their contributions. Very quick reply. My learned friend for Caroni East, I will have a chat with him on the side as to how the law works. The law does not work such that the expression of $250,000 and 6 months means $250,000 and 6 months. The Summary Courts Act governs this. The sections as they are proposed to be amended say that you must knowingly and willfully, etc. It relates to your mental intention. The mental intention is part of the element of the crime. The court has a discretion to offer no monetary sum whatsoever, $0 and 0 cents, no custodial sentence. So this is what you call the range of law. It's due process. You make your submissions to the court, and there's a very material provision in the Summary Courts Act, Section 71 of the Summary Courts Act, which is where you can even ask for a reprimand and discharge. So we must be careful not to frighten people into thinking that the law is automatically you've tripped it and you're exposed to $350,000 or $250,000. I mean no disrespect when I say that I'm willing to give some guidance on that aspect, as I'm sure some of your colleagues who are attorneys at law can do that as well. I'd like to say, Madam Speaker, that in relation to the information technology that will work alongside this system, they are mutually exclusive. So all of the protocols and connection aspects can happen. This law is just simply intended to have a consequence. At present, the consequence is $6,000 for breach of Section 7 and no breach consequence for breach of regulations. Last point with respect to the proportionality, it is why I said that we have in the Interpretation Act, the amendment, a breach of a regulation under Section 63 of the Interpretation Act. Any regulation made under law is called subsidiary legislation. It used to be that you were exposed to the whopping sum of $500 TT. That law was amended, so you have your maximum fine of $250,000. The public health regulations, which have been upheld by the courts, right up to the Court of Appeal, the breach of those regulations, maximum of $250,000. And I'll end by giving a simple example. If a ship captain comes in with a cruise liner and submits documents that are false, what would you suggest is an appropriate offense? $1, $5, $6,000? That's where the proportionality of applying it to the circumstances becomes relevant. So I'm confident that my colleague meant no disrespect to the Parliament in terms of its structure and the advice that I give as Attorney General on this. I understand my colleague's point of view. I hope he's a little bit more satisfied that there is proportionality in this law, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Quarantine Act, Chapter 2805, be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
An Act to amend the Quarantine Act, Chapter 2805.
The Attorney General.
Madam Speaker, in accordance with Standing Order 68.1, I beg to move that the Quarantine Amendment Bill 2021 be committed to the Committee of the Whole.
Honourable members, the question is that the Quarantine Amendment Bill 2021 be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? I think the ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. This bill has 2 clauses.
Clauses 1 to 2?
The question is that clauses 1 to 2 stand part of the bill. The question is that clauses 1 to 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 2 stand part of the bill. Honourable members, the question is that the bill be now reported to the House. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This committee is now adjourned. The House to resume. Attorney General.
Madam Speaker, I wish to report that the Quarantine Amendment Bill 2021 was considered in Committee of the Whole and approved without amendments. I now beg to move that the House agree with this report from the committee.
Honourable members, the question is that this House agree with the committee's report on the Quarantine Amendment Bill 2021. All in favour say aye. Aye. Any against? I think the ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Quarantine Act, Chapter 2805, be forthwith read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Quarantine Act, Chapter 2805, be forthwith read a third time and passed. All in favour say aye. Aye. Any against? I think the ayes have it.
A bill entitled An Act to Amend the Quarantine Act, Chapter 2805.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be now read a second time. Madam Speaker, I confess that I have been anxious all day long, as today is the last day that we sit as a Parliament before we go on the mandatory recess that our standing orders say, subject to events arising otherwise. I've been anxious all day long to get to this particular bill, and that perhaps was evident in the quick fashion in which we dealt with other business before this Honourable House. So I wish to tell honourable members that no insult or disrespect was intended, but this law before us, this bill before us, is in my mind one of the most important events for us to finish before we get to the conclusion of the work that we are obliged to do by the end of today's business. Madam Speaker, I think there can be no gainsaying that Trinidad and Tobago has had its eyes fixed on a deep desire for solution, that we have said to ourselves that we need to protect our vulnerable. And as a government, Madam Speaker, in bringing this bill before us, the government is saying that we need to operationalize our laws. Madam Speaker, the Sexual Offences Act, as the parent law, is an Act of Parliament number 27 of 1986. That's when we had a codification of a number of our laws, common laws, etc., and we put forward a statement of laws. Back then, Madam Speaker, marital rape was not even something within our mental reflection. But the Sexual Offences Act, be it in the protection of children, be it in the protection of the vulnerable, be it in the protection of the married even, is something that has progressed over time. Now, Madam Speaker, in the period 1999-2000, the Honourable Attorney General, then Mr. Ramesh Lawrence Maharaj, made amendments to the Sexual Offences Act and brought forward the concept of a sex offenders registry. That law, unfortunately, notwithstanding the fact that we had thousands and thousands of convictions for sexual offences, not a single person went onto the register, because the law was, with the greatest of respect to Senior Counsel Ramesh Lawrence Maharaj, it was just badly drafted. Because in that Part 3, you were required to find yourself registered as a sex offender, turning up in the police station to be registered whilst you were on your way to jail to serve your sentence. So it just didn't work. We had the pleasure as a government in birthing the Family and Children Division, in bringing to life specialist courts, in creating criminal proceedings rules, in bringing children's rules. Why? Because we're dealing with crimes not only amongst adults but also children, in anonymizing records, etc. We have had the pleasure of also, as a parliament, sitting under my hand, with the privilege that I've had to draft this law, to come up with the amendments to the Sexual Offences Act, importantly, to change the manner in which we have the concept of a sex offender, a registered sex offender. We passed that law via the good utilization of a special select committee in the Senate, and we operationalized that law. And in operationalizing that law, Madam Speaker, very importantly, we took advantage of judicial scrutiny. We immediately had a look at a particular judgment coming from the court, which is no longer a live matter before the court, so I can speak to it now. We dealt with the matter of the State and Everton Joseph. It's criminal CR number 090 of 2015, and the date of delivery of the judgment is December 9th, 2020, coming from the Honourable Mr. Justice Hayden A. St. Clair Douglas. And this case demonstrates how, for the first time, someone was ordered to be put as a registered sex offender. Now, a lot of Trinidad and Tobago's concern, we've had marches, we've had people crying out for justice. A lot of their concern has been, well, how am I going to have a degree of awareness as to who amongst us fit the category of monster, of a monster without rehabilitation? How are we going to protect our young, our vulnerable, and even not so vulnerable from sexual predators? And one of the tools, obviously, is the utilization of a sex offenders register. Because no one was put onto the register, we cannot now go back into time for the 20 years that were lost and put people onto a public register. But what we can do is to ensure that law enforcement has a full register, which is not available to the public, and that society has available to it another form of register, which is what this bill proposes to do. This bill proposes to create two registers. Not only the registered sex offenders register, but also the public website register, both of which are maintained by the Commissioner of Police. But permit me, in supporting the rationale for this law, to read the following from the judgment that I just referred to of Mr. Justice Sinclair Douglas. And I quote from paragraph 1 of the judgment, which starts off in quotations. It's under the heading Sentencing Note. Quotations. I never completed school as a result of having my kids at a young age. I had my daughter at the age of 13 years old. I was then a Form 1 student at the Barrett South Secondary School. After giving birth to my daughter, I went back to school and continued my schooling. I had advanced to Form 2, but became pregnant again with my son. I was 14 years old. I never returned to school after having my son. And then the judge says this after the quotations end. These are not the words of a young female in some isolated plantation or faraway rural community in 1940s Trinidad. These are the words of a young female who resides in an urban community in Trinidad in the 21st century. In the view of this court, this is unacceptable. Now, the circumstances of this case were such that the allegations that the court considered didn't involve rape in the forced version. It involved statutory rape. There was a relationship, etc. The offender, in fact, fathered children, successive children with this young lady. But the court, in saying that this was not a case that involved those positions, the court took a very important point of view. It took into consideration the characteristics of the accused. In looking at the sentencing guidelines, the court physically went through the matters, and it says that it is a clear impact to be considered: the age of the offender, the circumstances of the offender, whether the offender is looking after the progeny produced by the relationship, etc. And the court reflected upon this amendment that we as a parliament did, that this government did, when all other governments lay silent on the issue. The court reflected and made the award, putting this person as a registered sex offender. But the court went on to say that we are obliged to protect the vulnerable, and that young girls in this case are simply morally and physically off limits. And therefore, Madam Speaker, as we look to the amendments to the Sexual Offences Act by this law, let me flag right now that we have another set of amendments to come to the Parliament. We intend to amend the law to make voyeurism an offence under the Sexual Offences Act. We intend to amend the law to ensure that revenge pornography is criminalized. We intend to amend the law so that the aspects of bail in relation to sexual offences are treated with. Because, Madam Speaker, whilst many people have had the song and fury and dance and say, let's do more, very few have come forward with concrete proposals. Certainly with the rapidity and certainty and operationalized effect that this government has. And today we come in this bill to ask for the Sexual Offences Act to be amended. We are asking, Madam Speaker, in Clause 4 of the bill, to have in the definition of register the cross-reference to the correct sections as we propose them to be amended now, and that we insert the definition of website. You'll see that in Clause 4 in the definition section, Section 2 of the Act. We're asking for the website to mean the public sex offender's website established under 46AB. We, of course, then amend in Clause 5 the heading. Instead of having one heading which refers to one sex offenders registry, we're asking for a new Part 4 heading in saying that it shall be a sex offenders register. The sex offender registers, as I welcome you Mr. Deputy Speaker. Mr. Deputy Speaker, in Clause 6, we ask for the extraterritoriality to apply, that sex offenders falling within the registrable categories in Schedule 1 to the bill, into the Parent Act as it was amended, that we treat with sex offenders from abroad. Why? Because we know that there is a repatriation, a deportation of persons who commit sexual offenses in other jurisdictions, and therefore we wish to make it beyond doubt that extraterritoriality also applies. Mr. Deputy Speaker, we propose in Clause 7 how we set up these two registers, one called the National Sex Offender Register, and the other one called the Public Sex Offenders Website. In Clause 8, we deal with the National Sex Offender Register. And in this point, we say that the National Sex Offender Register shall, in relation to each registered sex offender, contain information set out in Schedule 3 and pursuant to Section 54. So let's deal with the process. You go to court, you're on a charge, a court convicts you, you are a sex offender. You don't become a registered sex offender until you are put into the system after having served time, or if the sentence is suspended and you are told by the court that you must register as a sex offender, you go to the police and there you register, and at that point you become a registered sex offender. So that is what goes on in Section 47 as it is proposed to be amended in Clause 8. And there we say that we need to do a few things in looking at the information that is available to the public, because the court says so. We want to make sure that that information not only is available to all of law enforcement, as we look at bringing information technology and we revolutionize the taxi system and what is referred to as the PH taxi system, which is coming to this Parliament, so that law enforcement, when it sees a driver on the road and scans a QR code, will know whether that person who is driving the car is a sex offender or not. What we also provide is that if anybody misuses this information, the registered sex offender information, that constitutes an offense. Clause 9 treats with the website, access to information on a sex offender's public sex offender website. And you'll note that, Mr. Deputy Speaker, what we are saying here is that a website shall be created. That website will have the sex offender's name. That will happen automatically upon the conviction, unless the person who is the sex offender makes an application to the court and says, look, I want to show cause why I should not be put on the sex offender's website. And then you have the due process of applying to the court, having the court say yes or no, appealing the decision of the court as to whether you should go on, and then taking that to the Court of Appeal. Obviously, you still have the right to the Privy Council, but we provide for due process. We respect the provisions of the Constitution, in particular, that there's no jeopardy in reversing a burden. In any event, it fits within the appellate structures of our court system and our constitutional arrangements. Mr. Deputy Speaker, again, we put the offense for basically fake newsing. This is a country, and my friends opposite will know this well, where fake news becomes news. Any story that you tell becomes news. This country is at a dangerous point where it is not a matter of what is the truth. It appears to be what is the version of the truth that you offer. And therefore, we need to protect the vulnerable. We need to recognize that the right to have somebody not go on the sex offender's website also includes the victims. Because you may have circumstances where a victim may approach the court. The parent law, of course, already treats with the fact that you cannot go onto the website if you are a child or if we are dealing with cases of incest, because those are important safeguards to this law. Mr. Deputy Speaker, Clause 10 treats with the amendment to Section 49 of the Act. And here it is that we treat with how the court is going to manage your attendance for registration. We tidy up the law, we tidy up the cross-section references, etc. But Mr. Deputy Speaker, I want to point out, even though you see the word shall in relation to the directions to the court, I want to remind that this shall is not offensive to the separation of powers principle. It is not so offensive because you have the right of appeal, and you have the right of due process, and you have the right of application. Mr. Deputy Speaker, Clause 11 treats with repeal and replacement of Section 50 of the Act. Section 50 is where we set out the information on the sex offender to be published on the public sex offender website. And here it is. You will see, Mr. Deputy Speaker, where we have the due process, that the sex offender may, within 14 days of such conviction or other period of time that the court may prescribe, apply to the court to be exempt from going on that website, or and show cause why he should be exempted. We then, in subsection 4, provide where the circumstance of where the court has not granted the exemption, that the sex offender has the right of appeal within 21 days of the date of refusal of the grant or such further time as the court may give. The court, pending determination of the appeal, shall withhold the making of an order. So you have the protection of not going on to the website unless the court facilitates your right of objection, your showing cause why. There's a mandatory statutory that you must press pause and not publish. But when the due process is over, when we look at the structures of the court also having the opportunity to ask for mental assessment reports built into this new Section 50, when we look at the factors set out in the new proposed Section 50 subclause 7, where we're asking the court to consider the findings of mental health assessment, the nature and gravity of the offense, whether the sex offender has been charged or convicted of any other registrable offense. Note that, including charges, risk of reoffending, the risk of harm to the victim or any other person, and that is where victim impact becomes material as well, whether the victim was a child or a person with mental disorder, whether the sex offender was in a position of care or abused his supervisory authority, whether the employment and resident status of the sex offender are stable, and any other compelling reason. Those are factors that the court must consider in saying that you ought to go onto the website. Clauses 12, 13, 14, 15 treat with the amendments by way of cross-sections, which we need to tidy up with these amendments if accepted by this Honourable House. Clause 16 treats with the amendment of shall to may. I'd just like to remind Mr. Deputy Speaker that by way of this Parliament's work, we amended the Sexual Offences Act last year, and in amending that act, we changed shall to may, and we allowed the court to have the discretion as to how it would treat with receiving mental assessment reports, etc. That was by Act number 29 of 2020, Clause 6 of that Act. So what we're doing, we are harmonizing the law now, changing these provisions from shall to may in accordance with Act number 29 of 2020, Clause 6, which is now Section 6 of that Act. Mr. Deputy Speaker, Clause 17 treats with Section 62. And again, we are looking at, because of the move from shall to may, we're looking at where the mental assessment report may be requested, because we're leaving it up to the judge to trigger the request for a mental assessment report, etc. Clause 18, again, is in keeping with the amendments of shall to may, as I've indicated we did in Act number 29 of 2020. Clause 19, again, we are now distinguishing between the positions of registered sex offender or a sex offender, because there's now a material clarification that the bill offers. Clause 20 treats with the adjustment of the fines, and we are moving from $50,000 to $250,000 for breach of regulations, and we're deleting 6 months and we're substituting 5 years. Why are we doing that? Because we amended Section 63 of the Interpretation Act, and we are therefore bringing this material in line with the amendments that we made last year, Mr. Deputy Speaker. Mr. Deputy Speaker, we're adding in the power of the Rules Committee of the Supreme Court of Judicature to make rules. And why are we doing this? We wish to not rely only upon regulations. We think it appropriate because as a government we have created a children's division and a criminal division, because we have allowed for criminal divisions to operate via criminal proceedings rules and children's proceedings rules, in addition, of course, to family proceedings rules, etc. What we want here now is to leave the liberty of the judiciary under the Supreme Court of Judicature Act to make rules which will govern these processes. Mr. Deputy Speaker, of course, we do the consequential amendments to the Administration of Justice Deoxyribonucleic Acid or DNA Act and the Police Service Act, where we put in what the amendment to the offences by way of regulations will look like, and also distinguishing between a registered sex offender and a sex offender. And then in correcting Schedule 3, we have to now fix the cross-references as is required. Mr. Deputy Speaker, this is law which we are anxious to see completed today so that the citizens of this country will feel a sense of acknowledgement, a sense of protection that the government not only hears what they say, but acts and operationalizes laws for the benefit of our society, well within the keeping of Section 53 of the Constitution, where we make laws for the peace, order, and good government of our society. In those circumstances, Mr. Deputy Speaker, I beg to move.
Honourable members, I have now proposed the question for debate. Member. Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be now read a second time. I recognize the member for St. Augustine, and as the first responder, you have 30 minutes.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, I, like the Attorney General, am anxious and happy to see this piece of legislation finally come to the Parliament. The United National Congress is on record as calling for the establishment of the Sex Offenders Registry to be established in Trinidad and Tobago. We have consistently been making that call since November of 2015. There are several instances recorded on the Hansard. And while there has been promises and positive words from the government, and I am sure as well that the voice of the people, that the current social climate, that the speaking out of our citizens to add their voices to this call has pushed the government to finally bring this legislation forward, and I'm very happy. Mr. Speaker, just for the record, I just want to mention some instances on the Hansard where the United National Congress, the members of the opposition, even in the previous parliament, would have made this call. In April 2016, Dr. Fuad Khan asked about public access to the Sex Offenders Registry. In March of 2017, MP Barry Padarath asked of the establishment of for the protection of children, the establishment of a Sex Offenders Registry. In March of 2018, Mrs. Vidya Gayadin Gopi Singh Orapuch West, again, and a follow-up by MP Padarath. And even then, Mr. Deputy Speaker, the Parliament, the opposition, the population has been told it's in the works, it's in the making. On record here, you also have Minister in the Office of the Prime Minister, Honorable Webster Roy, indicating, and I quote, "The necessary legislative framework has to be put in place and the Office of the Attorney General is working on it." So I know the Attorney General must be very happy to be here today because he has spent quite some time working on it since 2016, and we are happy to see it being brought to light. But I can tell you, Mr. Deputy Speaker, that the UNC has been consistent on calling for the establishment of the Sex Offenders Registry. And we have also been consistent of ensuring or asking that the views of the stakeholders be taken into consideration. The Attorney General, in his opening, indicated that consultations did take place. I am happy to hear him mention some of the recommendations that came from different quarters in terms of national security, surveillance, cameras, how many cameras are working and not working, the public transport, and so on. And we will continue to be the advocate and the voice of the people to ensure that these things do come to fruition. Mr. Deputy Speaker, the bill before us, the Sexual Offences Amendment Bill 2021, creates two registers: a non-public National Sex Offenders Register, which is also being referred to as the Police Register, and a publicly accessible public sex offenders website, which is being referred to as the Public Register or the website. The concerns of the possibility of vigilante justice, the concerns of privacy, protection from that, those things have been aired in the public domain for quite some time. I will go into a few of the clauses, Mr. Deputy Speaker, where I want to put on record, the opposition's support and raise these concerns in the hope that it could be addressed in this seat of Parliament, this seat of democracy called Parliament. Mr. Deputy Speaker, one of the clauses calls for sex offenders convicted outside of Trinidad and Tobago, including non-residents and non-citizens, to be placed on a register or a website. With regards to this, a person who is entering the country for 2 days or 48 hours, they have that amount of time before they are required to report. We have a concern, I have a concern I want to share with that, Mr. Deputy Speaker. I'll come to that later. But one of the major features of this bill is that whereas previously under Section 49(1) of the 2019 Act, the previous Act, a person convicted of an offense against Sections 4, 4A, 9, or 12 of the Act, or Section 18 of the Children's Act, was subject to a mandatory order to be registered under Section 54(1). A person convicted of a registerable offense other than those mentioned was only required to be registered under 54(1) in the discretion of the court. In both cases, a person could apply under Section 61(1) to be exempted from registration, or under Section 62(1) from the cessation of the reporting requirement. In this bill, that discretion of the court is largely removed. Under this current bill, all registered sex offenders must be included in the register, since under the new Section 49(1), the court must now order the registration of all persons convicted of a registerable offense, and it is subject only to an application for exemption under Section 61. So I know the Attorney General has indicated about the discretion of the court, but the discretion to not order registration for the majority of offences are now being taken away from the court. The accused, the convicted person, you have issues of their rights, knowledge of their rights, access to legal representation. In the case where a situation may have been publicized a lot, the identity of the victim is tied to the identity and the information about the accused or the convicted persons as well. But you know what this does? This provides more work and more money for lawyers because a person must have their attorney apply for the exemption. It is not left to the discretion of the court. And that is something that I feel that the court should have been left with the discretion that was provided in the 2019 Act. Mr. Deputy Speaker, the website, concerning the website, the court's discretion has been removed. All sex offenders' name and information under the 2019 Act were only included in the website when the court, at its discretion, made an order. So after a conviction, the court would then have to make an order based on the circumstances, based on the case, to have that go on the public website. That discretion, again, is something that I feel the court could have remained with. The Attorney General briefly mentioned the issue of mental health assessments. And Mr. Deputy Speaker, that is something that attorneys seem to prefer, the courts seem to prefer the assessment, because in many instances, a mental assessment report, it is no longer mandatory here, but that is how the court would consider applications for the sex offenders to be exempted from registering or reporting, for terminating their reporting period, or from expunging the information from the registrar. More than, in fact, many times, sexual abuse cases, sexual offense cases, especially those involving children, Mr. Deputy Speaker, mentally ill persons, are characterized by some degree of mental or emotional dysfunction of the abuser. Without that mental assessment, how does the court determine if this person should be exempted? The courts have long relied on reports from psychiatrists to help in their proper determination of sexual offenses matters. So this, Mr. Deputy Speaker, because we are talking about the protection of the citizens, the reason for the establishment of the register is to protect citizens from being potential victims. And the assessment of their mental health is a critical part of determining whether they are fit or not to be amongst certain people who might become potential victims. Mr. Deputy Speaker, I also want to touch briefly on, the issue of the special majority. I don't know why, Mr. Deputy Speaker, the Attorney General felt that it wasn't necessary to put the special majority in here. I feel that I just want to quote Senator Wade Mark in the Senate briefly, and and I think that really captures it. He said, the question has to be asked, why would the Attorney General want to encourage litigation against the state by passing a bill that requires a special constitutional majority with a simple majority. It is as if the Attorney General likes to spend taxpayers' money to defend challenges and then claims confidentiality so that we, the taxpayers, do not know who got what by failure of disclosing who the Attorney General has paid, how much he has paid to those lawyers, including his own law firm. This is from the answer there.
1 second.
Mr. Deputy Speaker, I rise on standing order 48.1 and 48.4 and 48.6. Having been in that house, I know that that was equally unfortunate in that house as it is here. So you can't just read it, Mr. Deputy Speaker.
Right. Again, member, with regards to your statement, even though you are quoting, again, based on the standing order identified, I will suggest that you move on from your point, please.
Thank you, Mr. Deputy Speaker. For the record, I was quoting from Hansard, but the issue is why risk the legislation being struck down as unconstitutional when you have been engaging the opposition
Deputy
to
Speaker,
support
and
and the special...
and the members continuing.
Again, members, I suggested,
Deputy-
kindly move on, please, to your point. 1 second. No explanation is needed, member. Right.
48.6, Standing Order 48.1, and Mr. Deputy Speaker, I'm asking for it to be withdrawn.
Okay, all right, members, thank you. Right, so member for St. Augustine, as I ruled, I told you to move on to your other point, right? And again, let's not go down that road that you are presently on to, please.
Mr. Deputy Speaker, I want some injury time. Thank you very much for your protection, Mr. Deputy Speaker. The main purpose of the Sex Offenders Register is to help the police service prevent and investigate sex crimes by giving police agency the access to data bank, information on convicted sex offenders, particularly their residence, where they are located, the ability to track and inhibit or prevent them from continuing with deviant behavior. Of course, the resources of the police management and monitoring for every sex offender, not only whether they have committed a very heinous crime or not, but every offender that is registered has to remain on the police radar. We must recognize the additional work now being handed to the police, the Trinidad and Tobago Police Service. And, Mr. Deputy Speaker, I call on the government to ensure that adequate police resourcing, financial and human, is given to the TTPS to ensure that this goes. This also goes for the forensic as well as the police resources. I come back now, Mr. Deputy Speaker, to a point concerning sex offenders who are convicted overseas and they come to Trinidad to visit. There's a requirement in the legislation for the sex offender to report to his nearest police station within 24 hours of entry into Trinidad and Tobago, where he is convicted by a court outside of Trinidad and Tobago. And he is in Trinidad for more than 2 calendar days. Why? Why more than 2 calendar days? What if a sex offender is only in the country for 1 day or 2 days and he can still commit an offense, he can still be a risk or potential danger during that time. So I'm asking, why report within 48 hours when you can also have, and you should also have, that the offender should be mandatory for the offender to report to the police immediately upon entry to Trinidad and Tobago. Whether the person is on our shores for 2 hours, 2 days, 2 months, or 2 years. The requirement here for that, Mr. Deputy Speaker, in my view, leaves a space, a loophole, for potential victims to not be protected because we are not informed. So I want to ask for a mechanism to be set up for reporting either at the airport or port of entry, or for the sex offender to be required to report immediately on entry to the nearest police station or the airport. Mr. Deputy Speaker, I think it's also important for me to mention assessing how this is impacting on our society. Assessing how the establishment of a sex offenders registration and notification system or policy, how it reduces sexual violence against women, against girls, and against boys as well. In some states in the US and in some other jurisdictions, when they implemented online sex offenders registration policies in the 1990s, they subsequently conducted studies, follow-ups, and this is where our own TTPS and criminologists will have a role to play, and that research must inform government policy. Follow-up, in terms of the number of new sex offenders being registered, the percentage of recidivism. The study ought to report, in a study that was a research report that was submitted to the United States Department of Justice, it dealt with the state of South Carolina. They started their system in 1995, but it showed some surprising results. So there were some positive impacts on the general deterrence associated with averting what they determined was approximately 3 new first-time sex offenses per month. So there was a reduction in first-time sex offenses. However, it still had no effect on deterring the risk of sexual recidivism. People who offended tended to offend again. It did not exert the intended effects on the judicial system in terms of non-sex crimes, and in cases where in those cases the number of defendants who were permitted to be placed on non-sex charges following the onset of the South Carolina policy for online notification, what they realized that there was actually a reduction in the community safety by increasing the likelihood that these defendants who were guilty of sex crimes pleaded guilty to non-sex crimes or were acquitted altogether. So we have to look at the net effect in terms of the change, how it affects our society. Now, the culture there in those countries in the US may not be the same as in Trinidad. We are a smaller country. We tend to know each other personally. The issue of vigilantism and a sex offender functioning in a community without being well known by members of the community is less likely to happen here because of how small our society is. However, we have to look at the effect this will have on our culture of treating with sexual offenders. Mr. Deputy Speaker, registered sex offenders who failed to register were seen as more sexually dangerous than compliant registrants, because you have the element of remorse in there as well. You also have those who comply with counseling, and this is where the psychiatric treatment and psychiatric evaluation, the mental health evaluation comes in. So we have, Mr. Deputy Speaker, another key element, I think, when I speak of our culture in Trinidad and Tobago has to do with how we as a society treat with persons who are involved in sexual offenses, whether it is sexual harassment or the very heinous and devious crime, whether we have crime against children, sexual offenses against children, and the message we send. It's important for our teachers to understand the role they play in protecting our children who may see them as the only refuge. they may be the first to know of instance where a child is being sexually abused. And they do have a responsibility under law at present to report if they know that a child is a victim of sexual, any kind of sexual abuse. The fact that an adult who is aware of an offense against a child has a responsibility in law to report that says something about how our adults should treat with sexual offenses. We have to continue to be examples as leaders. So in this bill, we are treating with publicity. We are proposing to publicize the names of convicted sex offenders. We are arguing in the public space, in the Senate and other places, about privacy, the privacy of the victims, protecting the victims, and the accused person's right to privacy, the convicted persons. We are speaking, Mr. Deputy Speaker, about protection in law for those who have been offended. We are speaking of protection of those who are convicted. We are also speaking in a large part about the protection of potential victims, ensuring that those persons who may be at risk in the future are protected because they have knowledge, upfront knowledge. And this, I just want to briefly mention, I had a conversation with the mother of Ashanti Riley. And one of the things that came out in the public domain is that there were people who were aware that her attacker had issues, what they call issues surrounding interfering with children. That's basically how it could be termed. But in other words, it was known to some persons that he had deviant ways. But because they had recently moved into that community, they were not aware of it. So the talk on the grapevine is a way of the community being informed. There was no official public register for her or her parents to know that that person had a record. However, the question in terms of whether a person is convicted, accused, or whether it's just common knowledge, village talk. This protection, the publication of a sex offender, only comes when a person is convicted. There have been instances where people have numerous cases before the court, they are not convicted, and therefore they will not be on the register. And so you will not have the protection of their names being publicized. Here is a concern. The length of time that some of these cases take to be tried in court leaves potential victims vulnerable. When a case could take 15, 20, 10 years, where a person has numerous sex offenses that he is accused and arrested and being tried for, and continues with his deviant ways, this person will not appear on the sex offenders registry. A big part of this registry doing its work is for the courts to be more efficient, to ensure the protection. Another part of this, Mr. Deputy Speaker, the part about the example of our leaders, has to do with how we in the public spaces treat even with persons of prominence who are either victims or perpetrators. How do we treat with the stigma, where holders of public office, either in terms of representation or in the clergy or anywhere else, but holders of public office who are accused of sex offenses or even sexual harassment? Do we continue with the culture of sweeping it under the carpet? Do we sign non-disclosure agreements with the victims? Do we protect the perpetrators while we are saying all other ordinary folk go and be named on the public registry, while you have non-disclosure agreements for persons high in society? We have to be careful about what message we are sending. In conclusion, Mr. Deputy Speaker, the United National Congress strongly supports the protection of women. We in the opposition, we strongly support the reduction of crime against women, protection of our women, men and children against sexual offenses. The United National Congress also supports good law. There are opportunities here, Mr. Deputy Speaker, to strengthen the legislation. And just as the Attorney General said he was so happy to see this piece of legislation finally coming after he has been working on it for years and years and years, I also look forward to another piece of important legislation, the sexual harassment in the workplace policy that has been promised by this government to come before this Parliament. Mr. Deputy Speaker, I thank you for this opportunity to contribute to this debate.
I recognize the member for Tobago East.
Thank you, Mr. Deputy Speaker, for...
20 minutes.
Yes, sir. Thank you, Mr. Deputy Speaker, for the opportunity to make a brief contribution towards this very important debate. I would first like to start off by addressing some of the issues raised by the Honourable Member for St. Augustine. Mr. Deputy Speaker, we live in a democratic society, and one of the things I would have learned being in a position now of a policymaker is how you balance rights. Because we live in a society where everybody wants their rights to be recognized, and we have to learn to balance that. And I'm saying this, Mr. Deputy Speaker, because I remember when we had initial discussions around this particular piece of legislation, there were some persons who were very adamant that all information should be public, you must be able to see everything. And then there were some persons who were very adamant, those who strongly advocate for human rights, and those who are of that nature were saying, well, what about the rights of the perpetrators? Mr. Deputy Speaker, it's a very difficult task in a society that's democratic to balance rights. However, I must say, Mr. Deputy Speaker, the measures proposed by the Attorney General in the bill, it balances the weight of just in terms of rights, but it also, Mr. Deputy Speaker, leans heavily on the victims, and I'm happy for that, Mr. Deputy Speaker. Mr. Deputy Speaker, whereas I may not have been a victim of any sexual violence, I know persons who would have endured that. Mr. Deputy Speaker, I know how uncomfortable it is to be peeped on. Whereas being peeped on may not be as serious as being raped, I knew how I felt. I felt violated, much less for somebody who would have had to endure either rape or incest or something like that, Mr. Deputy Speaker. One other thing I learned, Mr. Deputy Speaker, is that growing up in a very closed society, you often hear the whispers about what's happening here, what's happening there. I am from Tobago East. I grew up in Tobago East, deep countryside Tobago East. And I remember hearing the stories about, don't go in that car because Johnny Boy, known for touching people. Don't walk through that track because the man that lives at the end of the track is a pervert. I know the stories. So when the Attorney General and his team, and when the entire cabinet, when we were discussing this piece of policy, I was very excited because I knew we were bringing another measure of safety to the vulnerable in our society. But again, Mr. Deputy Speaker, it brings to fore the fact that legislation alone cannot bring about the required change in Trinidad and Tobago. And the Honourable Member for St. Augustine would have alluded to that. Even though we may have a register, one that is for the use by the public, one that is for use by the law enforcement personnel, that would not necessarily safeguard someone from becoming a victim. However, what would safeguard someone from becoming a victim would be all the other measures we put in place to start bringing about the change in mindset required in Trinidad and Tobago. I was on social media recently, and a young lady put up a post about her experience. And she was saying that her story is basically how I escaped. And she named the individual who would have been one of the persons identified in the, I'm assuming, the rape and murder of someone in Trinidad and Tobago recently. And she would have detailed her experience and how she would have survived, Mr. Deputy Speaker. And someone asked me to comment, but I did not comment, because I recognize that even though we may try to create laws, even though we may try to bring about programs, what we have to do as policymakers, as legislators, what we have to do, we have to become the champions of the change that is required in Trinidad and Tobago. And I want to say that again, we have to become the champions of the change by the way we speak, by the way we communicate. The Honourable Member for St. Augustine said for years they would have been clamoring for this particular bill to come before the House. And while they were clamoring, Mr. Deputy Speaker, we would have been doing the side work to ensure that once we brought this bill here today, there would be the necessary supporting framework to help those persons who may be potential victims, but also to help to safeguard the vulnerable in our society. And before I go into more details on the bill, I want to share with you, Mr. Deputy Speaker, and the public, some of the work done by the government thus far to help to protect the vulnerable in our society. The Honourable Member for St. Augustine spoke about, duty bearers understanding their role in terms of reporting sexual offences and reporting crimes. At the Office of the Prime Minister, Gender and Child Affairs, over the years, we would have trained hundreds of duty bearers so they would understand their rights, their roles, their responsibilities in terms of reporting violent crimes, in particular crimes against children. We'd have trained coaches. We'd have worked with teachers in our nursery schools. We'd have worked with even media personnel for them to understand their duty in terms of reporting such types of crimes, Mr. Deputy Speaker. Mr. Deputy Speaker, we have been working with our school children, helping them to understand how important it is for us to eradicate gender-based violence in our society. We have our UN Foundation program that is operating, where we are working with those young people so that we bring about the change of mindset that is required. We have been working with persons down in the southern regions of Trinidad in terms of Project Sarah, so they understand how, participating in human trafficking, encouraging it by maybe soliciting prostitutes, how that impacts on our wider society. We have been working with our communities, helping to bring about the knowledge around gender-based violence and how we should treat with it through our Shades of I, She play, which is a play that goes into communities, bringing to the fore information around gender-based violence and how we could work as a community, as a society, to curb such forms of violence. Mr. Deputy Speaker, we have been working in terms of our legislation and the agenda set out to bring about the change. But at the end of the day, it comes back again, and I want to say it again, it comes back to personal responsibility. And I want to call on my colleagues today in this Honourable House for us to make a commitment at the personal level to start talking differently when it comes to violence against women and children and violence on the whole. I was excited when the Honourable Member for St. Augustine got up and said, well, we are supporting this. And then she went on to find all different ways to say, well, this can't work because of this, and I'm not happy with that. And that is well within her right. But what we need to do, we need to start talking in one common voice so people recognize that in this house, we are walking and talking the same thing when it comes to violence and when it comes to protecting the vulnerable. Mr. Deputy Speaker, again, I say I did not personally experience sexual violence in the form of rape, but I know how it feels to be peeped on, and I know how violated I felt. So imagine for those persons out there who would have endured maybe incest or would have been raped, for them wanting us to come together as a house, as representatives, to shape a society that will ensure that they feel protected later on, and they see us in here playing the fool, Mr. Deputy Speaker. I think we are doing a disservice. Mr. Deputy Speaker, I want to commend the Attorney General because what this bill does it provides measures for us to be able to identify those persons who have the potential to perpetrate in terms of sexual offenses, but it also gives the public an opportunity to be able to be more alert and to know what is happening around me, who is going to come into my community, who has the potential to hurt someone in my community. The point raised by the member for St. Augustine about the persons coming into the country having to report within a certain time frame, that is something I could understand, because as a mother, I have 2 young daughters. I would want to know if somebody's coming into my country and they have a history of being a sexual...
Some mutterings on your side, please.
I want to know somebody who is coming into my country and they have a history of being a perpetrator and they're registered in their jurisdiction. I want to know if the person ends up in my community. I would want to know as quickly as possible so I could put measures in place to safeguard my children, to safeguard my young constituents who are vulnerable. So I understand that point. And maybe that is something we may need to look at as we further develop this piece of legislation, maybe something we'll need to consider further. As I start off by saying, Mr. Deputy Speaker, we live in a democratic society, so balancing rights is something that we all have to contend with. But at the end of the day, we want to ensure that we do what is best for those who are vulnerable in our society, those who are vulnerable in our community. So I understand a point raised by the honourable member. Mr. Deputy Speaker, in preparing for the debate, I would have reviewed some of the statistics brought to the Office of the Prime Minister, Gender and Child Affairs by the Children's Authority. And while we would have noticed, Mr. Deputy Speaker, that we still have a relatively high incidence of violence against our children, what was particularly disturbing to me was the fact that the second highest form of violence and abuse reported was sexual violence against our children. And it means, Mr. Deputy Speaker, that something very serious is happening in our communities today that we must address. And that is, how do we educate our adults that they recognize that they have a duty and a role to play in terms of protecting vulnerable children instead of hurting them. Mr. Deputy Speaker, the Office of the Prime Minister, Gender and Child Affairs, we have been rolling out a number of programs in our communities, educating adults as well as children about the rights of our children as well as the responsibilities that go along with those rights. And what we have developed is what we call a Child Rights Ambassador program, where we are training our young people or children to understand their rights and their responsibilities, and then they go out and become advocates. And I want to demonstrate how that is working. Mr. Deputy Speaker, recently one of my daughters brought her cell phone to me and she said, "Mommy, I just found a video of one of my classmates. Apparently, a young girl might have done a nude video for, I guess, you know, the boyfriend-girlfriend situation, I don't know. But for some reason, it ended up on the internet. And my daughter reached out to the young lady. She said to her, you know what that person did to you was wrong. So I said to my daughter, I said, how you knew that was wrong? She said, Mommy, you're always talking about the rights of the child and then no responsibilities. She said, I'm listening. She said she went on to counsel that young girl to tell her, you know what, you need to contact your parents or somebody else and let them know that you were violated because that person was wrong to put that video out. Even though you did it, you might have done it because you're young and you're naive. This is my teenage daughter talking to another teenage girl. She said, but that person had no right to share it. And she also said to her, she said, you know, that is a form of pornography. And I was impressed because I didn't realize that children out there are actually listening to us. So while we try to do these little things at our level in terms of policy and program, we also need the law to help to support it. But more than the law helping to support it, again, we need those persons to be the champions and to speak out on behalf of the vulnerable. Just as my little daughter spoke out on behalf of that young girl and said, we have to find help for her. Mr. Deputy Speaker, I remember last year, a young lady contacted me. And we spent about 2 hours on the phone, and then she subsequently called me again, sharing her experience about being violated from the age of 5. Mr. Deputy Speaker, and she said to me, she said, what is the hurtful thing? That person walking around normal in society. And I was thinking, you know, what other measures could be put in place to help protect this young lady and to help protect other persons who might have come in contact with that perpetrator? This public website would give persons in the community an idea, hey, what? Even a person walking around normal, and looking as though they're decent, they have something to hide. Be careful, be on the alert. So that is how we are trying to marry the legislation with our programs as well as advocacy, Mr. Deputy Speaker. Mr. Deputy Speaker, I want to encourage the people of Trinidad and Tobago to recognize that legislation alone would not solve the problems that we are facing. Programming from government alone will not solve the problems we are facing as a society. What it calls for is individual responsibility. Individual responsibility for us as individuals to decide to do better and be better. I remember when I was picked on, Mr. Deputy Speaker, my husband was very annoyed. And if he didn't have self-control, he might have been in jail for murder. And that is what we call about individual responsibility. He had to take that individual responsibility. No, I would not act violently. Let us report it to the police and see what will happen. And even though I went to the police and the police thought it was a joke and they were asking me, "Is he a birthday suit? What happened?" We still acted responsibly by not going to retaliate in a violent manner. So it comes down to persons deciding to do what is right and what is good and what is just in Trinidad and Tobago for us to bring about the change that we all require in our country. Mr. Deputy Speaker, I commend the Attorney General for this piece of legislation. I commend him for this bill. I commend him for the work. But I also caution all of us in this honorable House for us to lend our voices to another cause, which is calling on all our constituents to start doing better and being better, because that is the only way we could change our society. This is good work. This is commendable work. However, this would not solve the problem on its own. Coupled with the programs coming out of the Office of the Prime Minister, Gender and Child Affairs, the programs coming out from supporting ministries such as the Ministry of Social Development and Family Services, where persons who may have to leave their home situation could get this support from the state, different ministries, different agencies working together in tandem with individuals deciding to make a change, deciding to be different, deciding to be better, good citizens. That is how we're going to see the Trinidad and Tobago we all yearn for. I know the honourable members opposite would say, well, every sitting you come and say the same thing. But Madam Speaker, sometimes you have to keep repeating the message until you get the buy-in. That is important. Because I honestly don't think that it's just my duty to come here and speak to the clauses for a bill, because that would not make the change. But to remind persons that we are all part of this and we are all in this together, whether or not you sit on the opposition bench or government bench, we are all in this together because persons selected us to be their voices and to lead this society. And we have to be responsible. Sometimes we have to put aside the politics and do what is good and what is right. So as I said before, I may not have agreed with everything that the Honourable Member for St. Augustine said, but I commend her stance in terms of supporting this piece of work. And that is where we need to go. At times, forgetting everything and really coming and standing on a united front for the good of the people of Trinidad and Tobago. Mr. Deputy Speaker, I know my friend from Princestown will get up in a short while and say, "A crying crocodile tears." But Mr. Deputy Speaker, Mr. Deputy Speaker, I'm just having a little fun with my honourable friend from Princestown here. But Mr. Deputy Speaker,
Let's do it through the
Mr.
chair,
Deputy
please.
Speaker,
Do it through the chair.
Mr. Deputy Speaker, with all the jesting, what I'm trying to say is that we could do so much better as a country, as a people, if at times we really just focus on what joins us together than what separates us. If we focus on what unites us instead of what divides us, we could do so much better as a people in Trinidad and Tobago. And if today we make that start by us really supporting the work here and getting the full support of the opposition bench, and everyone saying the same thing, I genuinely believe that we could see the transformation happening in Trinidad and Tobago, Mr. Deputy Speaker. And with these few words, I just want to thank you for the opportunity. I want to thank the Honourable Attorney General for his work and my colleagues for all they would have done in terms of supporting the work of the Office of the Prime Minister, Gender and Child Affairs, as you go out in our communities and try to bring about the change in mindset required in Trinidad and Tobago to end gender-based violence and to ensure that our vulnerable citizens, in particular our women and our girls, that they are protected as well, so that they become valuable contributors to our national development. I thank you, Mr. Deputy Speaker.
I recognize the member for Princestown. You have 20 minutes.
Thank you, Mr. Deputy Speaker, for the opportunity to contribute and participate in the debate before the House today. Mr. Deputy Speaker, it is often said that the role of the opposition is to oppose or to criticize. When I first became a member of Parliament in 2015, I encountered a situation in my own constituency, and I would not refer to the children's names or identify the perpetrator. But suffice to say, one of the most heinous incidents that occurred in my constituency on me becoming a member of Parliament was a brutal rape of 2 young girls by their school teacher. The teacher subsequently hanged himself in a public cemetery, and it was later discovered that he was a repeat offender. Mr. Deputy Speaker, that prompted me to look for solutions, to make advancements in terms of recommendations in ways in which we can further protect women, girls, and the most vulnerable in our society with respect to sexual violence. Mr. Deputy Speaker, it was in November when I brought to the Parliament, November of 2015, when I brought to the Parliament the issue of establishing a sex offenders registry in 2015. At that time, it met lukewarm response by colleagues opposite, but with repeated questions and motions, it was then seen as something that could provide tremendous value in terms of addressing the issue of sexual violence, especially as it relates to repeat offenders. Madam Speaker, from 2015, when I first started raising this issue in the House, to listening to the Honourable Member for Tobago West and the Member for San Fernando West today, I'm very happy to join with both members in terms of supporting this particular amendment to the Sexual Offences Amendment Bill 2021. Madam Speaker, there are a few issues that I would like to identify on the onset, but repeatedly the member for Tobago West and the member for Tobago East, I'm looking at the nameplate, my apologies, the member for Tobago East and the member for San Fernando West often say to us in this House is that sometimes we may not get the legislation perfect. It may not be right at the very start, but it is a step in the right direction. And while I may not always agree with that stance and that sentiment, today I believe that we have taken a step in the right direction. It may have been for some 6 years too late as we look at the backdrop of several persons who have been the victims of sexual offenses in this country. But what this would mean is that it would give others who may be potential victims, Madam Speaker, the opportunity to not have repeat offenders especially prey upon them and to further empower them, because it's often said that knowledge is power. Madam Speaker, one of the very first things, and I know the member for Tobago East spoke about her work in the Gender and Child Affairs Unit at the Office of the Prime Minister. And one of the things I'm hoping that we see a rollout of, I know it was only short of 20 minutes today that the Honourable Member had to speak, but what I'm hoping that we will see in the coming weeks and months ahead would be a public awareness program and a public awareness campaign. Madam Speaker, I'll tell you why this is so important, especially for a constituency like mine that is considered to be a rural constituency. I have had so many instances of having, especially Child Protection Unit, get involved in circumstances as it relates to sexual offences, particularly against children in my own constituency. But what I found, Madam Speaker, is that many parents and grandparents who are the custodians and guardians of these children, often do not know where to turn. And yes, I understand that there is the support of the Children's Authority, the Child Protection Unit, etc. The sheer ignorance sometimes, Madam Speaker, of not knowing is usually a stumbling block in terms of getting the help that is required. And in preparation for today's debate, I looked at some of the other jurisdictions to see where they have established a sex offenders registry, that they have embarked on a public awareness campaign that actually worked as it relates to especially rural areas. And one of the suggestions and one of the recommendations, especially coming out of rural parts of Texas, I found, Madam Speaker, was that they utilize the schools. They empowered the schools by having the computers and the website available to parents in the school. So if you do not have a device at home, you do not have internet connectivity where you can go onto the website, Madam Speaker, when you go to pick up your children from school, you are able, through the systems that are put in place there by having someone to assist parents who may not be technically savvy in terms of utilizing computers and so on, to be able to assist them. And this is something that I'm hoping that we can utilize through schools, yes, member for Tobago East, but also through our representatives, MPs' offices, the office of the councillors, the regional corporations. I think, Madam Speaker, especially where we have seen so many instances, the Honourable Attorney General in the other place, Madam Speaker, in piloting this particular bill, spoke about the thousands of cases before the Children's Authority that deals with sexual offences against children. And Madam Speaker, I believe that this will be a step in the right direction, that we can work across the aisle with members opposite, that we can empower our constituents who will be able to benefit from today's work in terms of this amendment for the establishment of a public sex offenders registry. Madam Speaker, today's bill requires offenders coming from abroad to register themselves with law enforcement within 2 days of arrival in Trinidad and Tobago. And Madam Speaker, one of the shortcomings that I found with the bill, and I looked at other jurisdictions, particularly the UK, the US, and Canada, was that there is an explicit provision in their legislation that governs the sex offenders registry that compels and makes it mandatory for offenders who are registered on the National Sex Offenders Registry in their particular country to notify law enforcement through a specific criteria outlined in the law of these countries, particularly UK, Canada, and the US. And in the US, this is what happens. Even if you are not on probation or parole, the Sex Offender Registration and Notification Act, SORNA, is a federal law that requires registered sex offenders to inform his or her residence jurisdiction of any travel outside of the United States at least 21 days prior to that travel. You must provide information related to your travel itinerary, your contact information in the country to which you will be traveling, and the crime for which you are registered. So while we do identify a specific procedure in our legislation today with the Sexual Offences Amendment Bill that is before the House, of persons coming in, non-nationals coming into Trinidad and Tobago, the bill has a limitation. I'm hoping the Honourable Attorney General will speak when he's wrapping up, of whether or not there's a specific omission. I know the Honourable Attorney General did indicate that there are more amendments to come as we proceed, but one would have thought that if we were dealing with persons coming into Trinidad and Tobago, we would also be dealing with nationals going out, especially if we were looking at other jurisdictions, especially jurisdictions that we share jurisprudence with, Madam Speaker. Madam Speaker, if we look at the UK, if you are living in England, Wales, or Northern Ireland, the perpetrator who is convicted and on the sex offenders registry must notify the police of any intention to leave the UK for any period of time. Previously, you had to notify the police of any intention to leave the UK for 3 days or more, but this has now changed under the Sexual Offences Act of 2003. Madam Speaker, this is the information that one must provide. the date of departure from the UK, the destination country, or if there is more than one, the first and the point of arrival in that country. The points of arrival in any country that will be visited in addition to the initial destination country. The carriers, the offenders intends to use to leave and to return to the UK or to any other points of arrival where they are outside the UK but not internal flights. Details of accommodation arrangements for the first flight outside of the UK, the date of re-entry to the UK and point of arrival. Madam Speaker, essentially, by providing this information to law enforcement before you travel, it also allows the opportunity of the sharing of that information subsequently, Madam Speaker, to other jurisdictions. Madam Speaker, where you do not hold the required information at least 7 days before your departure date from the UK, example, because you need to travel at short notice, you must notify the police 24 hours before departure. You must also provide the other information detailed above, or as much of it as you know. Madam Speaker, that is what applies in the UK. In Canada, the marginal note compliance before leaving Canada. In Section 4 of your legislation, a sex offender shall not leave Canada before they report under this section. And again, a criteria is established. I know the Honourable Attorney General may indicate when he's wrapping up that the judge or a magistrate may have discretion, Madam Speaker, when granting bail in terms of these conditions set out. But this particularly, Madam Speaker, is listed in the legislation of the UK, Canada, and US as a specific provision that deals with the criteria set out for persons who are convicted who are on the register, Madam Speaker, to be able to leave the country of their nationality. Madam Speaker, there are just two other issues that I would like to raise, and I know that my colleague dealt with the constitutional requirements, except to say, Madam Speaker, under this 2021 Amendment Bill, some have advanced that there are new breaches to fundamental rights that have occurred. For example, a sex offender's personal information will be placed on the register and the website as an automatic consequence of conviction. This is a clear breach to some, Madam Speaker, of privacy. Information such as address, children's name, etc. Now, Madam Speaker, while we do understand the rationale for this sort of information being placed on a sex offender's registry, Madam Speaker, it is my hope that the Honourable Attorney General will address that matter raised by the member for St. Augustine in particular with respect to the constitutionality and those provisions, Madam Speaker. Madam Speaker, the final point that I would like to raise is a point that has found its way into the public domain. And I know there is a proposal before the Office of the Attorney General now, Madam Speaker, and hopefully the Honourable Attorney General will be able to give us some clarification with respect to whether government is looking into this. I know the member for St. Augustine told us it did take us a very long time from 2015 to 2021, but we are here. We are here. It is a way forward, but it is my only hope, and I remember the member for Arima and the member for Tobago East in particular, when they speak, they often ask, what is the way forward? Where do we go from here? And having taken a giant leap today, Madam Speaker, with this particular amendment to the Sexual Offences Bill, I believe that one of the proposals, and I'm not saying that this is the panacea to this entire issue, but I would like the Honourable Attorney General's thoughts on this matter because it has been making its way, especially as it relates to regional news and international news. And Madam Speaker, if you would allow me to quote from a publication done by Fox News. It says, the advocacy partnership entitled Operation Global Sex Offenders Registry is driven by a leading sex offender registry management solution for law enforcement. Offender Watch, along with the Caribbean Community Against Sex Crimes, CCASC, an initiative of nonprofit Zandoli USA. The endeavor is focused on propelling the other nations in the Caribbean community, officially dubbed CARICOM, to implement similar bills over the course of the next year so that they can create the unified registry between the Caribbean automatically coordinated with the US and stop international sex crimes and child trafficking before they occur. Madam Speaker, I would really like to put on the public record and congratulate the work of the chairman of this organization, Jonathan Bagan, as well as this group, because what it only intends to do is to make the database publicly accessible, but to implement a safe virtual neighborhood app in which parents will always know if their children's smartphones go near a sex offender's address, even if the offender is not on a public registry or in the US, which will require the cooperation of the Caribbean and beyond. Once we get the offender watch software implemented in the Caribbean, there will be less need for public registry since automation at the software level is more efficient, Mr. Bagan added. So, Madam Speaker, as I said, I know that this is a proposal they have shared with members of the opposition. I know they have indicated that this has been shared with the Office of the Attorney General. And, Madam Speaker, in raising that issue, I would like to turn to my last and final point, and that has to do with, Madam Speaker, that the 2021 amendment bill that we have before us, it seeks to amend Section 63 to increase fines for breach of regulations made under the Act. Yet to date, over 1 year and 6 months after proclamation of the 2019 Act, no such regulations have been laid. Madam Speaker, some will say to add insult to injury, Section 67A of the 2019 Act mandates that the minister shall cause to be laid in both houses of Parliament annually a report on the administration of this Act. The 2019 Act was proclaimed on the 31st of January 2021, and Madam Speaker, at least one annual report is due. Madam Speaker, on that note, it is my sincere hope as a member for Tobago East said earlier that for us to work together on matters like this that can be both beneficial to both constituents that are represented on either sides of the House. But, Madam Speaker, one must not speak from both sides of their mouths. And therefore, if a member for Tobago East is asking for us to sing in harmony, it is my hope that the honourable member will encourage her colleagues to have this report lead. And therefore, we'll have a better idea in terms of whether or not this legislation is working, and we'll have a better idea of where do we go from here. I thank you, Madam Speaker, for the opportunity to be able to contribute to today's debate.
Madam Speaker, when there seems to be unison and agreement on both sides of the House, I am very encouraged. And this piece of legislation, Madam Speaker, I think engenders that cooperation, and I would like at this point in time to commend the work of the Honourable Attorney General and the stance taken by the honourable members on the other side with respect to this bill. In my presentation, Madam Speaker, I will attempt to allay some of the concerns of the honourable member for Princestown, especially that of the constitutional rights, and say that this bill and this amendment is not intended to be used as a tool of punishment post the serving of a sentence. The rationale and the thinking balances the duty of the state to keep tabs on sexual predators and the requirement to alert law-abiding citizens of proven potential risks. Proven potential risks, Madam Speaker. Proven potential risks simply means it is only post-conviction that this bill becomes applicable. And even in those circumstances, Madam Speaker, this bill contains safeguards for sexual offenders post-conviction. Section 48(1), Clause 6 of the bill, provides that convicted sex offenders, once he or she appeals the conviction, the court will withhold the making of any order. So even when the presumption of innocence has been dislodged, there is still a second tier of protection. I am appealing this. Hold your hand, do not put my name on the register. Therefore, it fortifies my respectful submission to you, Madam Speaker, that the purpose of this bill provides, although it provides a measure of deterrence for convicted predators, it also provides some sort of alerting of the public of danger and lurking danger. It attempts to corral persons into controlling criminal urges and into modifying their behaviors. And I will demonstrate the sections which does so. Clause 6 of the bill, which is one of the main areas, it amends Section 45 of the Sexual Offences Act, and it widens the reach of the act to include sex offenders who are convicted of a registrable offense, be it within or out with the jurisdiction of Trinidad and Tobago. That is an important ingredient that has been added to augment the reach and breadth of this legislation. And Madam Speaker, the jurisprudence behind this bill, I know that this court in another incarnation would be aware of the principles of sentencing, but the jurisprudence of this bill is in keeping and mirrors the principles of sentencing as outlined in Benjamin and R. 1964 7 West Indian Reports at page 549. Madam Speaker, the 5 principles of sentencing are the punitive, the deterrent with respect to a potential offender, the deterrent with respect to an actual offender, the preventative, and the rehabilitative. The purpose of this bill is not to focus on the punitive, but it is to focus on deterrent and, in a way, help the rehabilitative and the preventative. Clause 7 of this bill seeks to establish 2 registers, the National Sex Offender Register and the Public Sex Offender website. The purpose of these registers, and by extension of the bill, Madam Speaker, in my respect.
Member for Digo Martin North East, I am being distracted. Please continue.
Thank you, Madam Speaker. The purpose of the bill, then, is to deter potential and proven sexual predators, and then to inform the public of the danger that may exist from such individuals. And via these 2 registers, the public will not only be informed, but they will be able to have access to published information via the Public Sex Offender website. And it caters also for safeguards and accountability with respect to the material that is being published. In other words, this piece of legislation seeks to strike that balance, that delicate balance between protecting the rights of individuals and yet trying to protect the public. And I say, Madam Speaker, that the bill has in most measures accomplished that. And the bill, as it seeks to strike that balance, it respects the rights of the offender and takes into account societal norms and issues, particularly Clause 8 of the bill, which amends Section 47 of the Sexual Offences Act and maintains, or it mandates now, that the National Sex Offender Register will not be accessible to the public at large. I say that for this reason. Madam Speaker, when unfortunate as it may be, persons find themselves listed on this register, there are consequences of obtaining a job. There are social consequences of becoming a pariah, getting proper housing, having stigmatization. What this bill does is, before this becomes something that is imprinted, because once it's out there, Madam Deputy Speaker, I'm told, when you're on your phone, be careful when you press send, because you may never be able to delete it. And that is why these safeguards have been put in place, particularly Clause 8 of the bill, in order to protect sexual offenders even after a conviction. Clause 9 of the bill, which amends Section 48(4), requires the name, date of birth, and photograph of the offender, but what it does not do, it prohibits the printing of the specific address of the offender. Madam Speaker, this goes again a long way in this balancing act of still protecting the public, but recognizing the rights that still exist, the inalienable rights of a person who has been convicted of a registrable sexual offense. Clause 11 of the bill, which includes new sections 52, subsection 2, 3, and 4, are very significant safeguards. Section 52 allows a convicted sex offender to apply to the court to be exempted from having his information published on the website. To answer the query and the concern of the Honourable Member from Princestown, this section allays all fears of breach of constitutional rights, and here is why it does so in my respectful view. The new section 54, when you make an application under section 52, subsections 2 and 3, it now provides that you can make an application before a court, and the court, Madam Speaker, in considering whether to exempt you, here are the considerations that the court must take and bear in its judicial consciousness. A, the findings of a mental health assessment. It means that the court will have an in-depth expert advice as to the psychiatric state of the applicant. B, the nature and gravity of the offense. Madam Speaker, you know that that is a very salient consideration in order for a court to take into account before either granting or refusing such an application. C, whether the sex offender has been charged or convicted of any other registrable offense. Madam Speaker, that is a real consideration. In other words, if the applicant is a recidivist, the court will be entitled to take that into account to say, well, look, you have offended in like manner before. Why shouldn't I now put your name on this register? D, the risk of reoffending. E, the risk of harm to the victim or harm to any other person. Madam Speaker, that goes directly to the jurisprudence concept of victimology. In other words, the court will consider in putting the name on the register whether the harm in putting it outweighs the harm in leaving it out with respect to the victim or any other person. That becomes very important in terms of households where, Madam Speaker, some of these acts sadly are committed. F, whether the victim was a child or a person with a mental disorder. This goes to the vulnerable. In other words, if the convicted person has a penchant and a proclivity to harm children or persons with a mental disorder. G, whether the sex offender was in a position of care, authority, or supervision of the victim. That goes, again, to a situation where there's a breach of trust, and it goes into the mix into whether or not the court will consider putting the name on the register. H, whether the employment and residence status of the sex offender are stable. And I, any other compelling reason in the circumstances of the case. So to answer directly the question of any constitutional breach, there can be none when, one, the offender has a right to apply to the court for exemption, and two, the court has a plethora of considerations, including any other compelling reasons not to or to include. In other words, Madam Speaker, there is due process, and in my respectful view, there is no breach of any constitutional right. So, Madam Speaker, having addressed that issue of due process, we want to say that the provisions of the register provides a database for the public. To the public of Trinidad and Tobago, Madam Speaker, danger lurks both within and without. It lurks both for male and for female equally. Therefore, this register provides an opportunity for the public and the members of, or the citizenry of Trinidad and Tobago to have care, to pay heed, to be cautious in their day-to-day activities. When we reopen, Madam Speaker, persons will be traveling late in the night. They may need to know what taxi and whose taxi they're going into. Persons in the home may need to know who they are bringing in to take care of their children. And this bill and the provisions and some of the provisions in this bill provides for that. Madam Speaker, there is one aspect of this bill which I have not heard members speak to, and that is there is a clause in this bill which provides for potential atonement. Clause 18 of the bill amends Section 63 of the Sexual Offences Act, and it allows an offender at some point in time to make an application to the court for the information that is on the register to be expunged from the records of the registry. Madam Speaker, that is a very important aspect of the bill. In other words, unlike other jurisdictions such as New Zealand, where once your name is on the register, it stays for life. In this context of Trinidad and Tobago, there is still an opportunity if the offender walks the straight and narrow to have the register, the information expunged from the record. It means then, in my respectful view, that the bill tries again, in my view, successfully to balance that concept of deterrence. Because, Madam Speaker, who would want to know that their name is up on a register as a sexual offender and predator? And it will encourage proper behavior and the controlling of dastardly urges that will guide and that will lead persons to commit acts and serious acts of indecency. In saying that, I close by commending on this side the bringing of this bill, commending on the other side the support that has been brought for this bill, and to say, Madam Speaker, that this is good legislation and I support it. I thank you, Madam Speaker.
Member for Tabakit.
Thank you, Madam Speaker. It is indeed my honor to participate in this debate today. I intend to make a very brief but pointed contribution. I think a lot of ground has been covered. I listened very carefully to the member for Tobago East, and listening to the contribution from the member of Tobago East, I looked over my contribution, and I can tell for a lot of it, we were on the same page. And that's always a good thing in an adversarial system, when you have persons on the same page. And that is because, as the Attorney General started, and as members, the member for St. Augustine, the member for Princestown, everybody who contributed here today said, what we're looking for are solutions for the people of Trinidad and Tobago, to provide solutions. And we've had quite a year, and it's only July. This year, we have, in the midst of a pandemic, faced untold horrors as a nation. We looked on at protests, we wept together, we agreed as not just politicians, but as citizens, that more ought to be done, and that those of us who have certain responsibilities ought to do whatever we can in whatever space we have. And as we sat as a caucus, we all discussed the areas we would contribute, but I wanted to come and present in this debate based on a letter I received in February of this year, in the midst of, I guess, our national trauma and what we witnessed at that point in time. And at that time, we had a number of persons agreeing to lobby their members of parliament. And I sat in youth government, and I was always very active in debate as a secondary school student, and then also as part of my university student body council. And I'm always heartened when persons, young persons in our society, or anybody really, take the opportunity to advocate for themselves and lobby their members of parliament, because I believe that is how we most effectively utilize our offices. And that is the only way we'll see the type of change Trinidad and Tobago truly needs and absolutely deserves. And so I received a number of letters, a number of emails, WhatsApp messages, and I noticed that it was drafted and it was part of a lobbying that was taking place early on in the year that asked persons to write to their members of parliament. And they were asking for some things that those of us who sit here and this is part of our daily lives would understand that they aren't really possible in some instances. But the mere act of writing to your member of parliament and saying, please, I am afraid to drive alone. I am afraid to walk on the streets alone. Running errands, recreational activities have become things that I am gripped with paralyzing fear to do in our country. And these are serious issues, and then asking me as their member of parliament to do something. And I wanted to just put on the record my response to a number of these persons, because it is directly related to this bill here today. And it is directly related because what we were talking about was what type of legislation would protect us from sexual offences. And at that time, the discussion was heavily centered around legislation. What can the parliament do? What can the parliament do? And that's why I said the member for Tobago East and I came here on the same page, because we are very well aware that while we are discussing legislation here today, and the Attorney General promised more to come, and we were happy to hear that, our solutions are not grounded in legislation. And as much as we would benefit from the sexual offenders register, as much as we will benefit from increased knowledge, we do need to do some other things policy-wise, and I will briefly itemize them as part of what I understood the call from the member for Tobago East to say, as well as the Attorney General, to say, let us do what we can to work together. And first up on the list, I want to urge members in discussing issues relating to gender-based violence, issues relating to sexual violence in our society. Please do your best to not minimize it into, if we had more stringent laws, we wouldn't face this problem. That is simply not true. We know that. It is not true. Do not promise that to our population. We could pass all the laws here today, and we could still have the problem tomorrow. So let us be honest when we are talking about these issues, because they are serious issues and they have a real potential for disrupting our society. So I want to start up, just say very quickly, education is key in this. We need to initiate a cultural shift in our education system. We need to look at our curriculum and introduce conflict resolution, gender studies at a young age, so that these problems are solved before you reach the question of whether or not you need a register to deter you. Because if you understand at a young age what kind of citizen we hope to create, then we will start to build that kind of Trinidad and Tobago that we see. So there's a great need for social awareness raised via our education sector at an early age. We will start to see the results we hope to see. There is an issue, and this goes into the education sector as well, but of resource allocation. Let us stop putting our resources at the end of the problem and start targeted approaches at the beginning, and that we will see, again, the kind of results we hope to see. And I listened to the Attorney General talk about the PH system, and I address that specifically now, and again, very quickly, because I understand what we're doing here today. But I just want to say, before, and this is again targeted approaches, before you get to talking about PH, there's something that an executive can do, which is looking at your public transportation and using that to ensure that persons can get safely to and from their destination. And I raise that in the context of whether you have a register or not, whether you know who the offenders are, because again, as a representative of our rural community, listening to persons, the person who wrote me this letter is in fact from Brothers Road, which is on the more rural end of my constituency. And there is no real choice in terms of how you get home. After a certain time, whatever car is going that way, you have to jump in it, or else you're walking. And so if we can look at the bus system, the PTSD system, we will again present the type of solution. And so I stand here today fully in support of any legislation that would become part of the solution that we hope to present to the population. And I hope that my contribution is taken not as saying that you're not doing enough. We may be saying that, but let us also look at how can we get into a productive conversation. Because even the Attorney General raised today this revenge porn being criminalized. And those things are, I mean, for somebody who's grown up in my generation, critical issues, because we face it on a daily basis. We just ran a political campaign where candidates in the campaign faced problems of this nature. And so we are happy to hear that. I can tell you, without a doubt, a number of people I know are waiting very patiently. So this legislation has benefited from the consultation that we oftentimes speak about. I sat in the other place on a special select committee. We listened to a number of persons. This legislation as presented may not make everybody happy, but we are balancing and we are trying to present solutions. And so my contribution here today say, while we look at legislation, look at everything else, because there are simple fixes, there are smaller, lower hanging fruits that will bear big results, and people are waiting on big results because they absolutely need it. And I thank you, Madam Speaker.
Member for Toko Sandigrani.
Thank you, Madam Speaker, for the opportunity to join in this debate. The Sexual Offences Amendment Bill 2021. Madam Speaker, let me take this opportunity to congratulate the Honorable Faris Alwari, Attorney General, for always bringing before this House sustainable bills, motions, and amendments.
Give the member for Toko Sandigrande the opportunity to make his contribution. We are all happy it's the last day. Let him be happy too. Please continue.
Thank you, Madam Speaker. Madam Speaker, these bills, motions, and amendments continue to positively impact the lives of citizens throughout this country while assisting Trinidad and Tobago to develop as a country. Madam Speaker, I stand proud as the representative for the people of Toko Sandigrande, who happens to be some of the most accepting and warm people of this country, Madam Speaker. Madam Speaker, in saying that, I have noticed that this act of kindness of the people of Toco Sangre Grande and other parts of Trinidad and Tobago has put us at risk for being vulnerable to sexual offenses and acts of indecency being perpetrated against us. Madam Speaker, I'm indeed grateful for this bill as it allows the people I represent and Trinidad and Tobago by extension a fair opportunity to protect themselves and their loved ones by having access to critical information on persons of suspicious behavior and activity before becoming victims of heinous crimes. Madam Speaker, just recently, Trinidad and Tobago went into shockwaves as we receive information about persons or perpetrators of serious multiple sex offenses. These individuals, Madam Speaker, lived, shopped, communicated, and operated amongst us, the people of Trinidad and Tobago, on a daily basis. Madam Speaker, these amendments will provide for the establishment of two registers: the National Sex Offender Register, which will not be readily accessible to the public. The court determines by way of order what information is posted about persons in this register and protects persons from time to time until they are proven guilty. The public sex offender website, Madam Speaker, which allows specific noteworthy information to be easily accessible to anyone at any place and any time. Only personal information such as name, date of birth, and identification, PITIE, convictions and address based on locality will be allowed, Madam Speaker. Madam Speaker, this bill will allow protection for the vulnerable in society. These amendments will give people a better sense of awareness and security as it relates to knowing the whereabouts of registered sex offenders via the newly implemented public sex offender website. Madam Speaker, I believe that every citizen deserves the rights to know if there is a sex offender or offenders in their midst, whether it be in their neighborhood, workplace, or the wider community. Madam Speaker, I am particularly happy to know that the Commissioner of Prisons or Psychiatric Hospitals would inform the Commissioner of Police at least 4 months in advance of the release dates of such persons. This will allow concerned family members to seek help and put measures in place to attempt the chances of their family members of re-offending, Madam Speaker. Madam Speaker, it will also heighten awareness of employers and concerned residents in the communities as to who these offenders are. Madam Speaker, when it comes to the powers of the Commissioner of Police, the accuracy of this information would be in the Commissioner's hands and not available to any and every person who may use this information for mischievous intents, Madam Speaker. This will ensure that only convicted sexual offenders and not those accused or have appeals before the court, Madam Speaker, is posted before they are officially convicted. Madam Speaker, you know we operate in a land that a man is innocent until proven guilty. Madam Speaker, it will also reduce the risk of innocent persons being uploaded and sensitive information being shared. Protection of the accused, Madam Speaker. Madam Speaker, this bill not only protects the victim of sexual offences, it also protects those who are wrongfully accused, Madam Speaker. Madam Speaker, I mean to explain that we all know of situations where persons engage in different type of relationships, and sometimes when they become exposed unwantedly, they make false accusation and tarnish the character of innocent people, Madam Speaker. Madam Speaker, I am also happy about the harsher penalties that this bill will provide, an increase by almost 400% from $50,000 to $250,000 in fines, and an increase of 4.5 years more jail time, Madam Speaker, for perpetrators of any such crime, Madam Speaker. Madam Speaker, I wish to inform this House that I fully endorse these proposed amendments, and I'm of the firm belief that no woman, man, or child should ever face such cruelty at the hands of these predators. I am happy that the information and their faces would be placed in the public domain, allowing an opportunity for us to protect ourselves and loved ones, as well as giving an opportunity to choose who we associate with, Madam Speaker. Madam Speaker, in this short contribution, before I close, I want to publicly let it be known that as a right-thinking man, I never possess such thoughts and tendencies, and I stand firm before this honorable House, giving my full support to these amendments, and I thank you.
Attorney General.
I don't propose to be more than 5 minutes. Madam Speaker, I wish to thank all honourable members for their contribution. I wish to say that whilst many governments have been asleep at the wheel, this government is not. I was very pleased to hear the member for Princestown adopt something which I thought quite astounding in recommending the work of Mr. Jonathan Bagan, the honourable member committing the UNC for that support. I'd just like to say the work that is being offered for discussion by Mr. Bagan is a sexual charges register, where charges against someone can be put forward. Now, I'd like to say that on behalf of the ministry, we are having that discussion right now, but that's a very avant-garde position. There's certain safeguards to be put in. If we are prepared to break the mold, I think that we'd be in a position to manage monsters. We have to balance it against due process rights of the golden thread of innocence in a society where you're innocent until proven guilty. That's a very serious conversation, but we are having those hard discussions now. And therefore, today represents an excellent opportunity for us to continue work. I can think of no better way to end the work that we're doing on this session, this side right now, than to thank my colleagues opposite for their support for the legislation that we have brought. I would like to thank my colleagues, in particular, the member for Tobago West, East, sitting in Tobago West seat, the member for Tobago East, the member with responsibility for looking after our children and vulnerable, a very understated honourable member at times, a fearsome warrior at all other times, but who I wish to compliment for leading the charge in protecting our vulnerable. Adding to that, the successive portfolios managed by Edmund Dillon, the Honourable Member Stuart Young, now Minister Fitzgerald Hines, in looking at the national security side. And I wish to give an open compliment to the Commissioner of Police, Commissioner Griffith, who has kept the technology and pace step by step in ensuring. Lastly, as I end, Madam Speaker, I'd like to sincerely thank the judiciary of the Republic of Trinidad and Tobago for ensuring that we get to where we go. Final words in gratitude to the members in the legislative departments and specifically at the AG Secretariat. We have a team led by some very amazing, passionate young people. The head of our criminal justice unit, Mrs. Farzana Nazir Mohammed, her entire team of young professionals, and the drafters, if I could just single them out, Ms. Tamara Dukaran, Ms. Shireen Haidar. They have given yeoman service in breaking all the boundaries. So with those few words, Madam Speaker, I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128.
Attorney General.
Madam Speaker, in accordance with Standing Order 68.1, I beg to move that the Sexual Offences Amendment Bill 2021 be committed to the Committee of the Whole.
Honourable members, the question is that the Sexual Offences Amendment Bill 2021 be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? I think the ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. This bill has 22 clauses. Can 1 to 22?
Should it please you?
Yeah.
Clauses 1 to 22.
The question is that clauses 1 to 22 stand part of the bill. The question is that clauses 1 to 22 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 22 now stand part of the bill. Honourable members, the question is that the bill be now reported to the House. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will resume.
Madam Speaker, I wish to report that the Sexual Offences Amendment Bill 2021 was considered in Committee of the Whole and approved without amendments. I now beg to move that the House agree with this report from the committee.
Honourable members, the question is that the House agree with the committee's report on the Sexual Offences Amendment Bill 2021. All in favour say aye. Aye. Any against? I think the ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be forthwith read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be forthwith read a third time and passed. All in favor say aye. Aye. Any against? I think the ayes have it.
A bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I beg to move that this House to now adjourn sine die.
Honourable members, the question is that this House do now adjourn sine die. All in favor say aye. Aye. Any against? I think the ayes have it. This House now stands adjourned sine die.